officer? Court officer? Audible ಇದೆಯಾ ವಾಯ್ಸು?
ಇದೆ ಇದೆ.
ಥ್ಯಾಂಕ್ ಯು ಸರ್. ನಾನು ಬೆಂಗಳೂರಿಂದ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೆ, ಅದಕ್ಕೋಸ್ಕರ ಕೇಳಿದೆ.
ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆಯಲ್ಲ, ಅದಕ್ಕೆ ಕ್ಲೋಸ್ ಇಟ್ಟಿರ್ತಾನೆ.
ಓಕೆ.
Sir, am I audible?
How do you make the judge become a vice versa? Now this, can we make it bigger?
Please,
Come tomorrow.
please.
My lord,
Being spoken to, there was
To
a,
the court officer, all the memos will come. That's what I'm saying.
My lord.
Don't mention.
one matter for pertains to recreation club matter, my lord.
Your matter also will come in the list tomorrow. If it is not urgent, I'll adjourn it. So give it. Yes, all adjournments.
Page number 7 and 8, page number 3, 9 to 17, page number 4, 18 to 27.
Which one?
Next week,
It may taken on next week, my lord.
Yes, 22. Post next week.
Please, oblige.
Yes.
page number 5, serial number 28 to 36. Page number, serial number 37 to 46. Page number 7, serial number 47 to 55. For petition. Page number 14, 84 and 85. Page number 15, 86 to 90.
Serial number 89, my lord.
89. Yes.
I request on next week, my lord, and date may fix, my lord.
To the petitioner,
Petitioner Omkar Desai, my lord.
you represent him.
Yes.
Request is on behalf of the council.
Petitioner, yes, my lord, yes.
Connected matter I appear for
Connected,
the
matter.
connected matter I appear for the petitioner, my lord.
Yes, all these matters after vacation, look at it. After, after 2 weeks, and any interim order is there, extend the interim order.
Please.
Yes,
Please,
next.
Lots, serial number 91. Lots, next week, lots. Petitioner council, lots have one. Lots, March 4th, lots, date may be fixed, lots. March 4th, lots.
We'll not give the dates. It will
Please.
come next week, you
Please,
can make a mention. Yes.
94, madam. I am for the petitioner. GMCPC matter. Pleadings and orders, everything is in Kannada.
Next week. Yes, next. All further hearing matters, delete. Delete from the list, post to the usual courts. And if interim order is there, extend in all those matters. 97 parted also, this also, delete. Yes.
Lordship, serial number 61, Lordship. Serial number 61.
Yes.
And for petitioners, file was misplaced, Lordship. Have it next week.
61 post after 3 weeks.
Serial number 24, my lord, it may be
20?
taken 4.
Yes.
Next week, it may be.
Yes, 24 next week.
Please.
For the list.
May I mention one matter? 79, my lords.
Yes.
Serial number 79, my lords.
70.
79.
Yes.
I seek short accommodation in this matter. To file objections, my lord, to the vacating stay.
Yes, at request of Land Counsel, the petitioner. This is matter after 3 weeks. Interim order only granted is extended. Yes,
Please,
next.
ma'am.
For the list. Accordingly, the civil miscellaneous petition is allowed by appointing Sri Justice A. N. Gopal Gowda, former Judge, High Court of Karnataka, as the sole arbitrator. Yes, next.
Much obliged, madam.
Deshpande, P. Hebbali.
CMP is dismissed.
Serial number 3, CBMD.
It's allowed by appointing the JM Kazi. ES4.
Serial number 4, Rakesh Mahesh. Vijay Bhatt.
Yes, CMP is dismissed.
Serial number 5,
Appear for petition.
R. Patil, K. Patil.
Writ petition is dismissed by affirming the order passed with effect quoted MA number 7.
So in this case, I filed
Delete from part third.
Interim order
in
make
this
it.
case. I filed a memo for disposal. What he has challenged is removal from the employment. Removal from the employment.
Delete from part third. Look at it if there is an interim order extend. List in the month of March. Yes, 7.
Date may be given. Once, if you kindly fix a date.
I will not fix any date. Yes, 7. Any urgency for this?
No, they have filed an impleading application. That is, I think that is not been shown in the court.
Let it move. List in the month, second week of March.
My lord, interim order may kindly be extended.
Interim order earlier granted is extended.
Please.
8. Yes, 8. Is post in the third week of March. Yes, in all the adjourned matters, wherever interim order is there, extend. Ask them to close the door. Every day I have to tell. Yes, 9.
Please, my lord. My lord, in this case, the petitioner is challenging the, my lord, the possession notice at annexure D, my lord.
Yes.
My lord, in this case, my lord, the petitioner has borrowed the 30 lakhs rupees.
Why the position notice? Why you have questioned it?
The outstanding amount is 24,46,000, my lord. The petitioner is ready to deposit 50% of them, my lord, outstanding.
50%. First of all, why should the courts interfere in DRT matters? Number 2, if you are not able to tell the reason, if it is a amount which you are ready to pay, court will grant time.
50%, my lord, he is ready to pay the amount, my lord. Within 3 weeks.
I've seen the latest judgment, yesterday, what Justice Suryakant, Justice Nagaratna, and bench of Justice Bakshi about this interference of high courts and DRT matters without any basis. So, if you're not making out a legal ground, at least you should be ready to pay the amount. Either of it, no 50% business.
Because petitioner needs some time, my lord.
But that's what I'm saying. You tell what is the time. Time is not 2 years, 3 years, keeping it pending here. If you're ready to pay the amount, come up with an affidavit. We'll consider the affidavit and dispose of the matter.
My lord, it may be have done tomorrow, my lord. I will ask to my client.
Yes, there's this matter tomorrow. Next 10.
Yes.
10.
Number 10.
In this case, my lord, I have filed the suit for injunction, and I have filed a suit for injunction before the trial court, and the trial court has rejected on the ground of the suit is maintainable in the district court as per amendment of section 20B of specific relief act. As per annexure F, in 27 districts are declared as a special court for entertaining the 20B of specific relief act. But Koppal district has not declared as a special court. Hence, the order passed by the trial court is not maintainable. Moreover, already district court has also not registered in the case as per annexure.
Where is the order?
Annexure G.
Page number.
Page number 46, Your Honor.
46.
Last page. 53 orders. The present suit is transferred to the special court established under section 20B of the Specific Relief Act 1963. And I have produced the annexure F, Your Honor, F, my lord. In the
So this is passed by the civil judge and JMFC Elburg.
Yalburgar.
And what is your case?
Yes, as per the page number 34, annexure F, my lord. and it is the order passed by the government. Which courts are the special courts, sir? And only 27 districts are the declared as a special court.
We'll find out. Passover.
Please.
Next 11.
Please.
Not Passover, tomorrow. Yes, 11.
Here, my lords, the interim maintenance, my lords, is challenged before this honorable court. My lords, wherein, my lords,
But for the wife or husband?
husband, my lords.
What is the amount granted?
My lords, 6,000 rupees is granted.
What is your income?
My lords, I am not denying, my lords, for 6,000. But only my grievance is, my lords, the arrears from the date of, the court has passed the order from the date of petition. In the year 2023, my lords, the case has been filed. On 13/1/2023, my lords, the petition has been filed. And my lords, in the month of March 2023, my lords, she has appeared. But till 2 years, my lords, she has not filed the application.
That would be from the date of application.
Yes, but my lords, the diligency, my lords, has to be shown.
File the application.
Please, lords.
When did she file the application?
In the year 2025, my lords.
Huh?
2025. Petition is filed in the year 2023.
Then that, from that day only court will order.
25/9/2025.
Let's see the order. What did the court say? Come to the order.
Please, lords. Page number 21 is the order. And page number 23, my lords, is the reasoning.
Number 2, filed with the respondent wife.
Yes.
Is allowed as interim maintenance, litigation expenses, so and so. Date of which petition?
From the main petition.
I don't think that's the intention of the court.
No,
I'll clarify that and I'll order notice. Learned counsel for the petition submits that. MC is filed in the year 23. IFO maintenance is filed in the year 25. But the court has directed the maintenance to be paid from the year 2023. Considering this fact, the arrears shall be paid pending consideration of this writ petition from the date of the filing of IA for maintenance. Notice to the respondents, petition is permitted to take out hand summons and file a memo to that effect.
Okay.
Yes, 12.
But plenty petition, my lord. My lord, the plaintiff has filed suit for a specific performance contract, my lord. My lord, after institution of suit, my lord, the wife and children of the defendant, my lord, they have filed the application under 1 Rule 10 to implead them, my lord. The implead
The suit for?
specific performance contract, my lord.
You are the plaintiff.
Plaintiff, my lord. It is registered as agreement of sale, my lord. My lord, the defendant, wife and children have filed 1 Rule 10 to arrest as a party to the suit, my lord. My lord, court has given finding, my lord, though it is a suit for specific performance contract, no one is necessary party to the suit except the who has executed the agreement of sale, my lord. But page number 17, my ink page number 17.
17?
My lord, para number 8, my lord.
Yes.
No, admittedly, the applicant are not a party to the contract. The defendant and applicants are the family members. Accordingly, the applicant, the suit is the ancestral property of the defendant and applicant, and they are having share in the suit property. In scope of suit or specific performance contract cannot be permitted to the third party claiming to be a joint owner of the property in the question. But in the case, the applicant claiming that they are having free existing right, man.
These kind of suits, except the contracting parties, no other parties are necessary parties.
Please, madam.
But in this case,
Please.
you have entered into an agreement with regard to a property which is a joint family property.
Madam.
Which is a joint family property which
Madam,
the defendant has no right to execute a
My lord,
sale deed in your favor.
my lord, though the trial court has observed that, my lord, even though joint owner is also not as a party to the suit, my lord, so in respect of specific performance contract is concerned, my lord. So even though court has observed, my lord, but court holds that the pre-existing rights is they have pleaded that it is a pre-existing rights, my lord. So therefore they are necessary party to the suit, my lord. In the first line, my lord, the court has discussed that it is a suit for specific performance contract, my lord. So, my lord, even though co-owner is also not necessary, my lord. So in the case on hand, my lord, the court has that they are having pre-existing rights, my lord. So it is not correct, my lord. They are not having.
Why they are not having right?
My lord, pre-existing, they are not having pre-existing rights, my lord. Because, my lord, in respect of
Property is a joint family property according to them.
my lord,
It's a joint family property.
Though it-
and the defendant has no right to execute a sale deed.
My lord,
agreement of sale in your favor.
If they,
No, assuming that.
Please, madam.
Tomorrow the sale deed will be, it has to be executed.
Please, madam.
When he has no power to execute the sale deed, when
Please,
it's a
madam.
joint family property.
They are having these proposed defendant are having right to file independently, my lord, in suit for specific purpose.
Please notice the respondent. Nothing is going to happen now.
My lord,
Will not stay the proceedings. Yes, 13.
please.
Petition is permitted to take out handsome and then file a
Please.
memo.
Have a session, clear shutter.
Yes. And in all these matters, in addition, notice to the respondents, in addition, and summons. Yes.
Well, it's the petitioner challenging the decree drawn by the Lok Adalat, my lords. Parties had filed the suit for, petitioner had filed the suit for partition, my lords. And it has been compromised, my lords. And so matter was referred to Lok Adalat. There's some discrepancy in the map, my lords. That is agreed.
What is illegality in that?
The map has to be corrected, my lords. The actual map is at annexure F, my lords. The correction has to be made, my lords. There is a little bit of difference in the square feet measurements, my lords.
What were you
The
doing?
boundaries have been wrongly mentioned.
What were you doing when you were signing the wakala?
When we approached for a subdivision, my lords, at that time, we saw that actual map, my lords, and there is a little bit of discrepancies.
So.
We're just seeking for issuance of notice, my lords. The parties have settled the matter, my lords.
I don't know what is the scope of writ petitions questioning a compromise decree. Notice
Only there is a
respondent.
difference in the boundaries, my lords, in the map.
There should be some right to you to come to the court and jurisdiction to the court to entertain the petitions of this nature. Notice, yes.
Bill number 14. Sharp Patpati. 14.
My lord, my application for issuance of, my lord, license, my lord, PDS license came to be rejected and the respondent application came to be allowed, my lords. Challenging that order, my lords, I am before this honorable court. Please, my lord.
Who are you?
That is annexure E, my lord.
Who are you?
My lords, I filed application for issuance of the PDS license, my lord. Even respondent, my lords, caveat also filed application for issuance of license. Where, my lords, the present petitioner application came to be rejected and the caveat petition.
On what ground your case is rejected?
My lords, on the ground that, my lords, I had not produced the SSLC marks card, my lord. Only on that ground. And not
What is wrong with his appointment?
My lord, see, he is not my first ground is that he is not from the same place, my lord. The notification issued by the state government, my lord, says that, my lord, the one who has, my lord, the.
On what you are saying that he doesn't belong to that village?
Please, my lord.
Basing on what?
Basing on the notification issued by the, my lord, the government, my lord.
Lord.
That I understand that
Please.
it says that he should be a resident of the local of that village.
Please, please.
Basing on what you are saying that he is not a local of that village.
Lord, his address itself, my lord, says that, my lord, she is the page 167, my lord.
That is one ground.
Second is, my lords, that in view of the notification, the one who has got the PDS, my lords, he has to transaction at least for 2 lakh every year, my lord. That transaction was not done by the respondent.
And that information, how do you have?
Please, my lord.
Where from you have that information?
The documents produced by the respondent itself shows that, my lords, they have not transacted.
Circulated to everyone.
Before the application, my lords, filing before the application, they have acknowledged all the documents.
It's true.
Please.
Your documents you will have, his documents he will have. How come you have the the documents of how did you have the benefit of looking at his documents? To assertively say he is not fulfilling this qualification, he is not fulfilling that qualification.
Please.
How?
Lords, because of the, my lords, notification issued by the state government, my lords, where.
What are your instructions?
Lord.
Rule 17.
Rule 17, alternative remedies.
Alternative remedies there.
Oh, he has raised two contentions with regard to his appointment. One is his non-local. The other one is that 2 lakhs condition he has not prescribed. Whether he is fulfilling the two criteria or not.
Yes, my lords. It is, my lord, forthcoming in the, my lord, impugned order.
Where do you get it?
My lord, page number 167. His application itself is incomplete.
Let's see.
Yes.
This is in
160.
Kannada.
167.
Oh.
Number 2 is, my lord, respondent number 5. Number 1 is the petitioner. They said, my lord, they have filed incomplete application. They did not furnish all the requisite documents, whereas respondent number 5 has furnished all the documents, Lordship, and accordingly has been selected, Lordship. And now, my lords,
It is just a general statement here.
No,
No,
no.
he has come up before the court. You have the document to show that you fulfill that criteria.
that is, my lord, the authority has to furnish.
That has to be dealt with the under appeal, my lords.
Huh?
The section rules.
There is a provision.
Yes, my lords.
What is the provision?
It's a question of fact, Lord.
Rule 17.
Rule 17 under the said
Page
order.
158, my lords, they have produced the, my lord,
Rule
audit
7.
report, wherein 4,000.
Rule
only, my lords.
17. Rule 17, order 2016. Huh.
Rule 17.
Rule 17.
The appellate authority may on its own motion filed by so decision of the authorized authority take up for appeal or revision any inquiry or proceedings of authorized authority exercising or failing to exercise. So why can't you go? Why can't
Yes.
you go under 17 and why should you come here?
And therefore, the
My lord, the order passed by the, my lords, same authority, my lords, again I had to be go
No.
before the,
Who is the appellate authority?
my lords, state only, my lords, appellate authority.
Authority.
Commissioner.
Huh?
Commissioner,
of
my
food,
lord.
Commissioner of?
food and civil supplies.
Who has granted
deputy
license?
commissioner is the appellate authority, your lordship.
And who is the authority granting this license?
Joint director, lordship.
So it's not the same authority.
Yes, it is not the same authority.
My lord, I'll
He
verify,
has
my
to
lord.
approach, my lord, appellate authority. My lord, it is a question of fact, your lordship. He has to adjudicate.
Assertively saying
Then
that,
only,
why
yes.
should you verify that?
Yes, my
Lord,
lords.
both
And
are, my
these
lord,
all, my lord,
same
disputed
government,
facts.
my lord. Page 128, my lords, the report, my lord, submitted by the.
All these are disputed questions of
Please.
fact.
Yes.
Which has to be, all these facts needs to be verified by the authority who is having all the records. Why should a
Yes.
high court go into all this? Please come. Agreed with the order, the presented petition is filed. Seeking the following prayer. Then counsel appearing for the petition submits that. He has, the petition is a registered cooperative society.
My lord, may I make one submission, my lords. I'll file memo for withdrawal, my lords, tomorrow, my lord.
Yes.
Please.
It is submitted that the petitioner will file a memo seeking to withdraw the petition. This is matter tomorrow. Yes. Yes, next.
Lords, I'm challenging the Lok Adalat decree, my lords, without making me the party. My brothers has compromised the, challenging the Lok Adalat decree, my lords.
Happened, you're saying without the?
Without making me the party, my lords,
You.
I am a sister, my lords. My brother has themselves have compromised and sold the property to the of the family. There has been no partition till today, my
So
lords.
you are not a party to the compromise. What
Please.
is the remedy available to you?
It is a Lok Adalat decree, my lords. I have to, remedy is, my lords, to challenge before this court, my lords. Writ is the remedy, my lords.
No, you can't file a separate suit.
My lords, the urgency,
Not a party.
urgency is, my lord,
Party to the proceedings.
but one,
There's no question of laying fraud on you. You are not a party. You can file an independent suit.
but my lords, challenging the compromise decree, the writ is the remedy, my lords. Lok Adalat decree.
You are not a party to
I am
the-
not the party, my lords. Only remedy is to file a 226 writ, my lords. Now the urgency is, my lords, they have filed the execution, my lords. Compromise has been occurred in,
In all CPC matters, every alternative matter is questioning the compromise decree. No, this compromise, recording compromises by the local Adalat should be stopped, I think.
that too, my lords, in this matter, my lords. Today they filed the suit, my lords. Tomorrow they have compromised, my lords.
Come to that compromise.
My lords, order sheet, my lords, at annexer, page 30, annexer C, my lords, page 29 is the order sheet, my lords. Registration, date of registration, my lords, 24/11/2020. On the next day itself, my lords,
Where are the parties? Let's see. Where is the cost title?
cost title, my lords, respondent number 1 herein is the plaintiff, my lords. And other
Number 17.
17. Please, my lords.
Hmm.
Plaintiff is the respondent number one here in my lords, one who has purchased my lords,
One who has
purchased the property.
the suit for.
Suit for specific performance, my lords.
Hmm.
Respondent number, defendant one.
For specific performance, by who are you? You are a contracting party.
I'm my lords, the property they have sold is the joint family property, my lords. My share has been sold, my lords. The entire property has been sold, my lords.
Can't you file a declaration or can't you file a suit for partition saying that this property is a joint family property? When the suit for specific performance, what will you do?
Lords, now they are, execution is filed, my lords, they are executing, my lords.
Notice to the respondents.
Lords, may I seek, my lords, the execution is, my lords.
No. Notice to the respondents.
Number 16,
And
Santosh Kumar P. Maligwad.
Could I appear for petitioner, my lord? Seeking for defreezing of the bank accounts. It appears that police have already intimated my bankers to defreeze my account. Nothing survives in this petition.
Then counsel appearing with the petition submits that the bank has already.
Police have intimated to my bankers to
Police
defreeze.
have already intimated to the petitioner bankers to
Defreeze there.
to defreeze the account. Hence, nothing survives for consideration. Accordingly, dismissed
Please, obliged.
as infractions.
Infraction.
17.
Till number 17.
My lords, on submission, in this case, respondent number 2 is the district judge, my lords. We are not appearing for the district judge. This is the, my lords, scheme under which, my lords, the members of the managing committee has been appointed. By mistake, last time, my lords, it has been stated, we have taken a notice for the,
Why you are taking notice by mistake? You shouldn't take.
yes, my lords, MB Hiremath appears for respondent.
What is the matter about?
My lord, the annexure A, my lord, scheme. Wherein, my lord, so far as category 2 is concerned,
And counsel appearing for the petitioner submits that. The fourth and fifth respondents are appointed as trustees to the third respondent temple, contrary to the scheme formulated. When is that?
annexure A, my lord,
Page number?
A 12.
Contrary to the scheme formulated in CS number 5 of 1906. It is submitted that the respondents 5, 4 and 5 have not endowed anything in favor of the temple. In that case, they are not entitled to be appointed as trustees as per the scheme. Considering the submission, there shall be stay of all further proceedings pursuant to the
Annexure
proceedings
G.
dated,
Sorry.
pursuant to the proceedings dated
Annexure F, my lords.
23/8/2025.
Annexure F, yes.
As far as respondent number 4 and 5 are concerned.
They should not function,
Huh?
My lords,
to
already they are
restrain from
appointed.
functioning.
No, when we grant stay of further proceedings itself, then he
My lords,
can't do.
the order
Notice to
dated, my
respondent.
lords, order dated 23/8/2025. Order dated, my lords, the annexure F is the, my lords, 23/8/25.
23/8/2025.
Yes. By that time, by this time, they would have taken a charge, my lords.
So once it is stayed, everything has to go. Notice to all the respondents.
My lords, respondent number 2, MB Hiremath appears for the respondent number 2.
Let it go. Notice to all the respondents.
Till number 18. Chandrasekhar.
Petitioner, my lords. The respondent is 20th depend in the trial court, my lord. She failed to file written statement within a statutory period of 120 days, my lord. That's the
I have dismissed several cases. Notice.
Issue notice.
19.
Till number 19.
stay of
Issue notice. Potresh.
stay of
P.
proceedings.
What is
No,
number
it has
19?
to be dismissed, in fact. I'm issuing notice. Yes, 19. Yes.
Potresh.
Please, my lords. Petitioners herein are the plaintiffs before the trial court. They had filed an application as per annexure F, my lords, for summoning the witnesses. As mentioned in the list of witnesses, the evidence of those witnesses is very incumbent to prove the case of the plaintiff, my lords. The application has been rejected by the honorable court below. Same as challenged herein, my
On the
lords.
ground.
My lord, their evidence is very much incumbent. Witness number 1 and 2 in the list of witnesses, they are not the family members of the plaintiffs, my lords. They have
What is the suit for?
suit for declaration, my lords. Declaration of sale deeds as illegal and not binding upon the share of the plaintiffs, my lord.
Come to the order. Where is the order?
Yes, my lords. Order is at Annexure H, my lord.
Page
My lord,
number.
at page 103 and 104, my lord.
Come to the reasoning
Yeah.
part and read.
Yes, my lords. My lords, this application was one among the series of application which the plaintiffs had filed. Along with this application, IA number 24, the plaintiffs had also filed other two applications for recalling the evidence of plaintiff and for production of the documents, my lords, on behalf of the plaintiffs. Interestingly, those applications has been allowed. This application has been rejected, my lords.
It will be. When is the suit is of the year 2015?
Yes, ma'am.
The plaintiff has filed, both sides evidence is closed.
But
Case for argument. At this stage, the
Yeah.
advocate for plaintiff filed application seeking permission of the court for production of documents. No doubt the plaintiff is.
May I invite the kind attention of honorable.
However, one more opportunity is given to plaintiff for production of documents, lead further evidence.
Yes, ma'am.
However, you are the defendant in the suit.
No, my lords.
Then-
I'm for the plaintiffs. I'm challenging the order on IA number 24. It is at page number 103, 104, my lords. Both these applications have been allowed, but on subsequent application, which was in connection to those applications, that has been rejected, my lords. That was for summoning the witnesses.
Once we'll order notice to the defendants and we'll say them to question this. And
My,
we'll
my
satisfy
lords,
this
the
order.
witness number 3 is not at all known to the plaintiffs, my lords.
The court
He
is
claims to be the GPA holder of the.
being too liberal to you.
Yes, my lords.
We can't expect the court to be more liberal than this.
My lords,
Notice to the
I'd like to bring the kind attention of this honorable court. My lords, we are insisted to argue before the trial court, my lords.
Please do it.
Our rights would be curbed, my lords.
Notice to the respondents, it's 20.
Cell number 20. This is Jnana Swami.
On the last occasion, this honorable court directed me to file a undertaking affidavit.
I've seen the affidavit.
I received the affidavit, my lords.
Yes.
My lord, part payment is mentioned by March 2026. That is the financial year end. If it is 50%, then.
That's called for 50.
Please.
When you're getting the money, if you just leave it like this, there are matters which are pending for years together before this court.
My lord,
Without any amount.
Since 2016, we have given a lot of time, my lords. It's almost 10 years.
Finally, now you
Please,
can, now he will lose the opportunity to come to the court.
please, my lord.
Yes,
please,
exactly.
please.
The writ petition is filed, seeking the following prayer. When counsel appearing for the petitioner submits that the petitioner was to pay the money and because of the financial difficulties, he couldn't pay the amount. If a reasonable time is granted, he would be paying the amount. Then this court has directed the petitioner to come up with an undertaking affidavit. Today, an undertaking affidavit is placed before the court by serving a copy of the same on the counsel appearing for the bank. It is stated that the petitioner undertakes to pay the outstanding amount of 15,59,632 within 4 months. And he is ready to pay the part of the payment by March 2026 and remaining amount will be paid within 3 months. How vague this affidavit is? Part payment means what? You will pay 100 rupees to them on.
Part half amount, my lord.
That why should
50%.
we understand? You should say 50% of the money.
I'll rectify.
Party is there.
Yes, ma'am.
Ask him to correct this and mention the amount.
Please, please.
Yes, and once it is done, tell the court officer, he'll call the case. Yes, mention it, what is the amount you're going to pay.
Please.
Yes, next.
Cell number 21. Chetana.
Yes.
Biraj.
Please, Your Lordship. Your Lordship, the petitioner herein had availed the housing loan, Your Lordship. Housing loan he had availed, Your Lordship. And he had almost
What is
paid.
the outstanding amount?
Outstanding amount is, Your Lordship, 10,18,000, Your Lordship. Lordship, he is ready to settle the amount, Your Lordship, provided some concession is given, and he has already given a representation in the month of January.
What is concession?
Your Lordship, one-time settlement, Your Lordship.
For that, you have to ask them whether whether it is in place or not. Which Karnataka Gramin Bank you appear? You
I've already served
Please
the
get
copy.
So papers on you.
I've already served, Your Lordship.
Copies have served, my lords.
Sir, one time the OTS is there.
My lords, in respect of OTS, my lords, I had to secure the instructions.
That's what. Tomorrow? If it is there, we'll dispose of the writ petition, directing them to approach the bank. And you have, if it is, let them, if they are not doing it, you can proceed.
Kindly have it tomorrow, Your Lordship. We'll approach them.
The so-and-so takes notice on behalf of the respondent. The respondent shall get instructions whether there is a OTA scheme prevailing as on today. Yes, next.
Grateful. Wishes, full amount.
23.
Seal number 23, 22 urgent, seal number 23. Rajshekhar.
Yes.
Rajshekhar.
No representation list after 4 weeks. Yes,
Seal number
25.
24 urgent, seal number 25. Sen Bankar.
Yes.
21.
Arising out of Chit Fund Act, my lord. Notice may kindly be issued to respond number 1 to 9.
Yes, the respondents. Yes, 26.
Issue notice. Seal number 26. Vijay Kumar. Shilman.
Heard for some time in the last occasion, my lord.
The respondent.
I obtained loan from the bank. I had mortgage.
So that is ready to clear the outstanding amount. We'll come up with your undertaking affidavit.
Yes, my lord. I am filing affidavit.
Have you given him a copy?
I have
No.
given, my lord.
What do you say?
Now he has served the copy, my lord, but
Let's see the affidavit. Take that. What is this undertaking affidavit?
One submission, my
Why
lord.
will the bank give you an OC to sell the property? Why can't they sell the property on their own?
No, not this property, my lord. That is altogether a different property which my father owned.
You're not concerned with all. Affidavit should never contain all these reasons. Affidavit is an undertaking saying that you will pay the amount.
Only one submission. Because my father owned that property, he had mortgaged
Oh,
that
how
property.
much time you're seeking? 1 year or 2 years?
It will be almost 1 year,
We
about.
can't give 1 year time for payment of the money. Please argue on the merits of the matter.
Only one submission. My father owned separate property. He had mortgaged that property. Now he has repaid all the loan amount. And now they have to issue in NOC. If that property is sold, this loan amount will be satisfied. That is the reason I filed that affidavit.
We can't tell the bank to do what they are to do in the usual transaction.
They are not
Can't tell
purposely
the
issuing
bank.
the NOC, my lords.
Not the scope of writ petition. What you're asking to quash the auction conducted pursuant to the notification dated so and so. Why should we do it? What is the reason behind this? What is the legally, what is the argument on a legal aspect?
Legal aspect, I do not have any case. That is the reason.
Go to the DRT.
The arbitration is conducted, arbitration is done, and award is passed, and auction is held, and
award is not challenged.
auction has taken place in respect of one property. My only
Yes.
request to the bank is.
the award
if
was
they give-
passed in 2022, my lord. Award was
2022.
23, my lord. The award is not challenged. Thereafter, my lord, on 4 times, my lord, the auction proceedings are conducted. Ultimately, my lord, the 4th respondent has become the successful bidder. He has paid the entire amount to the bank. At this stage, my lord, he has come up before this
Present
honorable
petition
court.
is filed seeking the following prayer. When the matter came up on the last occasion, it is submitted by the learned counsel of the petitioner that is ready to pay the amount. Then this court has asked the petitioner to file an undertaking affidavit. Today, the undertaking affidavit is placed before the court. And as per the undertaking affidavit that is filed, is seeking a year time to pay the amount. This court cannot accommodate the petitioner by granting the time as sought for in the undertaking affidavit. The petitioner is not able to make out a case seeking interference of this court under Article 226 of the Constitution of India. Learned counsel appearing for the respondent bank submits that. When was it passed?
21/4/2023, my lord.
Award was passed.
Please,
21/4.
2023.
2023, it is submitted that right from that day, the petitioner is had the enough time for the last 3 years, and there are no reasons to interfere with the auction proceedings as auction purchaser has paid the
Entire bid amount.
When was it paid?
Let, that particular date
Auction
is
purchaser has paid the entire
fourth
amount.
respondent hearing.
Having heard the counsels on either side. When the petition has come before this court, questioning the auction conducted by the bank, unless and until the case calls for an interference from this court, the court under 226 cannot interfere with the same. Petitioner could not make out any legally terrible grounds in interference of this court. In that view of the matter, this court do not find any reasons to interfere, accordingly disposed of, giving liberty to the petitioner to avail the appropriate remedy, if any, in accordance with law. Please. Yes, next.
Fourth respondent, my lords. Fourth respondent, my lords, I may permitted to.
Fourth respondent?
I may permitted to file wakalat, my lord. I'm
For
the
fourth
successful
respondent,
bidder.
so it's permitted to file wakalat within 1 week. Yes,
Please.
next. 27.
Still number 27.
Petitioners are the brothers and sisters, my lords. They are having ancestral property at survey number 143.
What is this writ petition about?
Mas regarding that, my lords, they are issued a notice regarding purchase of my land. Even though there exists an
No, who has issued?
assistant commissioner, my lords.
Let's see, what is the relief you are seeking? Come to the prayer. Quashing the proceedings in portions of the dated
36.
13/6/2022 notice you are questioning now.
No, I am not questioning. They are proceedings are pending since from last 4 years. They issued notice in the year 2022 stating that we are in a plan to purchase your land for the purpose of graveyard. Till now, my lords, they have not proceeded, not permitting me to utilize that property. The neighboring land, which is also part of the notice, was permitted to convert into NA land. But they are not permitting my property to convert it into NA land. Even there exists a graveyard.
Nothing but arbitrariness, high-handedness on the part of the state. Who is this? Who are the respondents?
My lords,
Array of parties.
Respond number 2 is the assistant commissioner who has issued the notice. And formal party is the respond number 1. I have made
So
the.
right from 2022, you are not using the land.
No, they are not permitting me to utilize my land
What purpose they want this land?
for graveyard. Convert it into graveyard.
Neither they acquire the land nor let you use it on for your.
No, they are.
Right from 22.
Oh, yes.
So I'll take instruction.
No, which law permits this respondents to behave like this?
Then they have done tomorrow.
Very unruly manner.
And
The land council appearing for the petitioner submits that in the year 2022, a notice was issued by the Assistant Commissioner, Dharwad, 36 on the date 36/2022, that they required the land for the purpose of
sorry, ma'am. Intending to purchase the said land
intending to purchase the said land for the purpose of
graveyard.
It is the case that right from 2022, neither the respondents have purchased the land nor they have paid the compensation to the petitioner. It is submitted that the adjacent land, they have permitted the adjacent landowner to convert the land.
Already converted, my lords.
And convert the land, and it is already converted. This court, in several cases, is observing that the respondents, without any authority, without following the due process, and are neither purchasing the property nor paying the compensation, and nor they are letting the people enjoy their land, and they are depriving them of their legitimate right. The second respondent shall respond to the same, and the instruction shall be on record. It shall come up with instructions by Friday. The learned AGA takes notice for 1 to 3. If the instructions are not on place on Friday, the assistant commissioner shall appear before this court. Yes, next.
I also sought for interim order, my lords.
It's only Friday. On that Friday, I will allow your writ petition.
Please, much obliged.
If no instructions are placed on record, he shall appear, and that would be the ground to allow the writ petition.
Seal number 28.
Appear, my lord, for the petitioners. Lord, first petitioner, my lord, is a trust registered under the, my lord, Bombay Public Trust Act.
Straight away come to the prayer.
Prayer, yes. Declare that the petitioners herein are the duly constituted committee of management, bar chairman and trust committee members, are trustees of Sri Mahakali Mayaka Temple Trust, Chinchli, Taluka Raibag.
The declaration.
Lord, this is in view. This is, my lord, in view of the vacuum created, my lord, since Bombay Public Trust Act came to be, my lord, repealed in Karnataka with effect from 1/5/2003 by virtue of, my lord, Karnataka Act number 33 of 2001, that is Karnataka Hindu Religious and Charitable Endowments Act 1997. This, my lord, the validity of this act was, my lord, challenged before this honorable court, my lord, division bench struck the.
I'm aware of it. I'm aware of it.
Yes. Lord, matter is pending before the, my lord, honorable apex court. In the meantime, my lord, amendments were brought, my lord, the interim order granted by the honorable apex court was, my lord, vacated in respect of sections 25 on 31/7/2009. In the meanwhile, my lord, in 2011 and 12, by way of amendment, my lord, new section, my lord, section 25 was sought to be inserted. That was also put to challenge, my lord, before this honorable court. Ultimately, this honorable court, my lord, in WP 6.
25 as of now is stayed by the Supreme Court.
Adu kuda stayed. Now what has happened is, thereafter, my lord, in 2023, the deputy commissioner issued a notification for appointment of a government nominated constitution, my lord, management committee to the various notified temples. That action, my lord, is challenged, my lord, by the first petitioner Temple Trust in a writ petition before this honorable court, WP number 1077 55 of 23, wherein an interim order has been granted, my lord, by this honorable court. As of now, my lord, the committee which is constituted under the, my lord, Bombay Public Trust Act, my lord, is still, my lord, holding the, my lord, management of the trust.
No, under the Bombay Trust Act, once a committee is constituted, that committee will be eternally functioning.
Not eternally. Now, in view of, my lord, neither there is.
For 2003 is that act is the new act has come. So then you are functioning under which act?
Lord, this is the original committee, my lord, constituted under, my lord, Bombay Public Trust Act.
That's what I'm saying. Under the Bombay Trust Act, if a particular committee is constituted, that committee will function for how many years?
Lord, as and how, my lord, committee gets reconstituted, there was a provision, my lord, under the provisions of Bombay Public Trust Act to report the changes. Change report, my lord. Now I am without any, my lord, forum to report the changes. Now the committee which was constituted and approved in 1992, my lord, existed till 2003. 15-member committee, out of which, my lord, 9 members expired.
Ask the AG to come. Yes, next. 29.
Seal number 29. Shiva Shuru.
Yes.
Suit is for partition. I am for the plaintiff, my lord. During the matter was posted for the defendant evidence. I have led the evidence as a PW2 and I have been cross-examined by defendant counsel partly. Further, my lord, on one occasion I was not represent. I was absent, my lord. PW2 was absent. On that day, my lord, my examination for chief was taken as a nil.
Come to that order.
Page 28, my lord, for a moment.
28.
Case called out, PW2 absent, no representation. Chief examination of PW2 is kept on record subject to the admissibility. Accordingly, further plaintiff evidence is closed.
Then
Page 27, my lord. In the mid case called out, PW2 present and fully cross-examined by defendant number 5 to 11.
What has happened next?
My lord, next I have filed an application for recalling of this order.
That order will.
That order runs from, my lord, page 36. The reasoning starts from 39.
Why Why are you dragging on the proceedings from 2017?
But this is, in fact, I'm the petitioner, my lord. I'm the plaintiff. I'm not dragging, my lord. But
You
there
are
are
not
19,
interested to take to
there
a
are
logical end, that's what it means.
rightly, my lord. Now my only submission is, my lord, my chief examination is over. If I did not offer myself for the further cross examination, my evidence will be vain, my lord.
And counsel appearing for the petitioner plaintiff, who is examined as, who is a PW2, submits that just because on 2 occasions the PW2 was absent, the court has closed evidence of PW2. It is submitted that if he is not cross-examined, it would cause a lot of hardship to the plaintiff. As such, an opportunity, a court ought to have granted an opportunity considering the submission. They shall be free of all further proceedings. So and so. No hand summons, memo shall be filed by 13th of March, or else the stay granted by this court stands vacated.
Notice only in respect of defendant number 1 and 5. Only those 2 defendants are opposing my
What
plea.
about others?
I'll seek a dispensation. I'll file memo.
Notice to
1 and 5.
1 and 5 other defendants are not necessary. Memo is filed, that are the docket order. Give it right now.
Hello.
Yes, 30.
My lords, I'm appearing for the petitioner in this case. My lords, the petitioners are class 12 students who are appearing for Karnataka CET examination. For Karnataka CET
This matter,
examination.
this matter before the court having roster.
Lordships,
Yes, next,
this
Sadiva.
matter, my lord, I accept notice for respond number 2, my lords.
My
That's
lords,
why I think it is before this. Do that.
It is only a.
Give it. Yes, yes.
My lords, in this, it's a very small error, my lords, the software error. Because of the technical glitch, my lords, the applicants were not able to submit the application under category. They were forced to submit under the general merit category, my lords. My lords, if you may kindly look at page 107, my lords.
One submission. I'm awaiting instructions, my lords. My request for tomorrow, my lords. I'll secure instructions and make the submissions. Obliged.
It's next, 32.
Seal number 31.
Lord,
Sham.
defendant's petition, my lord. My application for recall and reopen of the cross of PW1 application came to be rejected.
Yes, suit is of which year?
2019, my lord.
When was the evidence closed?
Notes the plaintiff evidence closed in the year, my lord, 2022.
Why you want it to be reopened
Please,
in
my lord.
25?
During the pendency of the suit, my lord, the plaintiff have filed an appeal before the DDLR. The same came to be rejected, my lords. Thereafter, my lords, I marked that document, my lords, as annexure. Then I wanted to, my lords, confront it.
Appeal rejected.
My lord, Lord, my application page number 53, my lord. I mentioned that, my lord, that during the pendency of the suit, present plaintiff was filed appeal before the DDLR Belgaum, challenging
There
the
should be
use of this
something, there should be some date, something for that.
date, my lord, sir.
With all these kind of vague averments, if you file a petition, why would the court allow it? Notice to the respondents.
My lord, I'm seeking for, my lord, stay of the further proceedings. my
Notice to
lord.
the respondents, the hand summons, list this matter. If the memo is filed, list this matter on 6th of March.
Please.
Yes, 33.
32. SC chat club. 32.
Please.
32.
Please, ma'am.
Yes.
Madam, the obstructor application was rejected in the execution proceedings, madam. Obstructor application, madam, 21/96.
37.
Madam, this property has been allotted to the present petitioner in the partition, madam. So, without impleading this person as a party to the proceedings, they have obtained the decree, madam, partition decree, madam, and thereafter they have filed a petition, madam, and thereafter they have filed the execution proceedings. After coming to when they have taken the
Partition is a oral partition.
oral partition, madam. Madam, we are the stranger to the family of the plaintiff, my lord.
Then where is the partition?
My lord, my brother has purchased the property through registered sale deed, my lord. I have enclosed the sale deed in the 1994, my lord. So that property in the
Property is not a joint family property.
no, my lord. That property has been allotted in the partition, my lord. to me, my lord, in the year 2011, my lord. So thereafter, during the pendency of the execution proceeding, I have filed the application or obstructor application when the possession warrant has been issued, my lord. The courts hold that, well, may I take the attention, my lord, page number, my lord, page number 19, my lord. There are only two grounds the rejected, my lord. The third party cannot be filed the obstructor application. One ground, my lord. Another ground, my lord, the inquiry is not necessary and filed the third party application. Third person, my lord. There are two grounds. Page number 19, my lord, para number 10, my lord. Under the provisions of 21 or 97, the third party has no authority to file application seeking the relief of impleading him as a party to the execution proceedings. Further, the provisions of 21 or 58 declare that all the questions relating to the right, title, and interest in the property attached between the parties to proceed or other representative should be determined by the executive court and not by the separate suit. Thus, the rule deals with the adjudication of the claim and objections to attach the property in execution proceeding. In other words, the person whose property is wrongfully attached.
And counsel appearing for the petitioner submits that the properties belong to the petitioner, which is purchased by the
Brother of the
petitioner by virtue of a registered sale deed,
1994.
which were later allotted to the petitioner in the partition. What are the properties now going to be executed in the execution proceedings? In respect of those properties, delivery of possession is
Please, versus possession warrant has been issued.
possession warrant is issued. And he has filed a petition under 21 Rule 97. The court, without considering the same, has dismissed the petition. Considering the same, they shall be stay of all further proceedings. Notice to respondent.
Please.
Same hand summons. Memo shall be filed by 18th of March, or else the stay granted by this court stands vacated.
Please.
Number 33, Ganesh Rai Bhai.
My lord, respondent number 1 is the cooperative bank, my lord. Respondent 2 is the borrower. Respondent 3 and 4 are the, my lord, the guarantor. My lord, petitioner is said to have, my lord, the petitioner's property has been attached for, my lord, the giving the recovery of, my lord. I have no vehicles. I have not mortgaged that property. So somehow with the respondent number 2 to 4, my lord, committed fraud on the bank, my lord. They mortgaged my property and started recovery, my lord. Recovery proceedings has been stated, even though I have filed application before the, my lord, trial court. My lord, without considering, my lord, now the order at annexure A has been.
What is wrong with this order? Section 14
My lord,
order?
my property, my lord, I have not mortgaged it. My lord, property extraction shows that
What
it's
is the
standing.
relationship between you and the other respondent?
No, I have no way concerned with bank, neither bank, my lord, not responding 2 and 3. I have not mortgaged that property also. And recovery started against me.
Who appears for this District Central Cooperative Bank?
My lord, I have to verify.
Huh?
I verified. I don't
Then
know.
counsel appearing for the petitioner submits that an order under section 14 of the Surface Act is passed, wherein the magistrate, wherein an order is passed under section 14 of the Surface Act, it is submitted that the property belongs to the petitioner. Petition is unconnected with the borrower, connected with 2, 3. When did you purchase this property?
My lord, log back at 4, 5. My husband was purchased in
Where
30,
is the
30,
sale?
35. My lord, property extract is standing on 14, page number 41, my lord. Your lordship may kindly, the property is standing in my name. I have been paying the tag
It
property.
is a registered sale deed.
My lord,
Registered sale deed.
registered sale deed, I have not, my husband, I have not produced a registered sale deed.
Produce the sale deed. This is matter tomorrow. If you produce the sale deed, then I will pass an order. Tomorrow, S34. Next.
Seal number 34.
Appearing for the petitioner, Lord Annexure K is the, my lord, the impugned order. Lord, the petitioner filed application under order 16 Rule 1 and 6 to summon the investigation officer to prove the statements made by the respondent number 1 and 2 and the son of the claimant, my lord. They have statements, my lord. Initially, my lord, the accident occurred on, my lord, 26/9/2022. After lapse of 3 days, the son of the, my lord, claimant has filed the complaint before the police, saying that, my lord, the claimant is the pillion rider. On next day, my lord, on 30/9/2022, he says that, my lord, he is the rider of the motorcycle. During the investigation, my lord, the investigation officer, my lord, the taken the statements of the respondent number 1 and 2, and also, my lord, the son of the claimant.
Please read point number 1, page number 45. Is this the impugned order?
This is the impugned order, 45 point number 1. On considering all the paper on record, it can seen that the respondent number 2 has filed I number 7 under order 16 rule 1 and 6, read with section 151 of CPC, praying to examine the investigation officer in relation to the statement of complainant and respondent number 1 in the interest of justice. It is the argument of counsel for the respondent number 2 that investigation officer has filed charge sheet against the
Will the investigating officer will depose contrary to the charge sheet?
No, my lord, he has not the respondent number of the son of the respondent and also.
Oh, he has already filed the charge sheet after a full-fledged investigation.
That
You can't elicit anything contrary. He will not say anything contrary to the averments in the charge sheet because he is the officer who has filed the charge sheet.
My lord, that charge sheet has been challenged by the my lord claimant before this honorable court and obtained the stay, my lord. To my lord, only to my lord the criminal proceedings has been stayed and they have pursued the proceedings before the my lord the tribunal. That's why my lord to prove the contents
Can you prove? Court was right. Charge sheet is already filed.
filed, my lord.
What is the purpose you're going to achieve by?
My lord, now my lord,
investigating
the claimant have denied the statement made before the investigation officer, my lord. That's why, my lord, to prove the my lord the statement,
For that charge sheet is there. Charge sheet is there.
charge sheet is there, my lord.
And if you call him the statement, the same statement he will say.
But the statement, my lord, made by the my lord the son and my lord the respondent number 1, contrary to each other. Initially, they stated that my lord, he stated that my lord,
Where is the application? Let's see.
application, my lord, annexure, my lord, H page number 37.
Please read.
The petitioner has filed page number 38 is the my lord memo facts.
Page number
38.
38.
38, my lord. Application is, my lord, page number 37. May I read, my lord, first?
Yes.
For the reasons stated in the,
Read the affidavit.
please, my lord. Memo of facts has been filed by the council, my lord. My lord, the petitioner has filed the top noted petitions claiming compensation on account of injuries sustained by him in the alleged road traffic accident, which occurred on 26/9/2022. The Iowa has filed charge sheet against the petitioner for rash and negligent driving and causing hurt only after recording the statement of the complainant, respondent number 1, and other witnesses.
For whatever statement that is made in the charge sheet, you want to again ask the same thing to the investigating officer and elicit from him what is stated in the charge sheet.
Because, my lord, he has the evidence, witnesses of the my lord, the very complainant as well as the claimant himself have denied the my lord statement made before the investigation officer.
Then what is the purpose to be achieved? That I am not able to understand. They have denied.
Please.
Now now you will call the investigating officer. He will say they have given me the same statements. That is what he said so in the charge sheet also. So what is the great help that will that gives you, that strengthens your case?
My lord, the charge sheet filed against the my lord the claimant due to rash and negligent driving of the rider of the motorcycle, that is my lord the claimant herein. Due to negligence on the part of the rider of the motorcycle, the alleged accident took place, who had no driving license at all. My lord, if the my lord the
So the contents of the charge sheet are in your favor.
please, my lord, that has been challenged before this honorable court, my lord. If this honorable court, my lord, quash the charge sheet, I will, my lord, no case, my lord, because, my lord, initially, my lord, they have given the state.
Whatever you will elicit from him, once the high court quashes the charge sheet, nothing remains to be considered.
Lord, that is, my lord.
Please come. The present petition is filed. Agreed by the orders passed and I number 1 in MBC number 2494 of 2022. The petitioner before this court is the insurance company or RTC?
Insurance company.
Insurance company. They have filed I number 1 or I number 7?
I number 7, my lord.
This is I number 7 in I number 7 under order 16 rule 1 and 6 read with section 151 CPC to examine the investigating officer in relation to statement of complaint and complaint. That came to be dismissed by order impugned. The court has observed that
Nothing has been, my lord, given any reason.
The court has considered the judgment AR 2024 SC page number 796. And in view of the said citation, the tribunal is of the opinion that respondent number 2 have not made out sufficient grounds to grant order in their favor. Therefore, I number 7 is dismissed. Then counsel appearing for the petitioner submits that the claimants are denying the statement that is given to the police, basing on which a charge sheet is filed by the police. In fact, they have questioned the charge sheet and obtained a stay. And when it comes to the Motor Act, the MVC proceedings, they're proceeding before the court. In that view of the matter, it is necessary to examine the investigating officer. The court has failed to consider the same and dismiss the application. Anything else? The heard the learned counsel for the petitioner. The contents of the charge sheet are in support of the case of the insurance company. Now that charge sheet is questioned before the High Court, and the stay is granted in the said case. No useful purpose would be served by examining the investigating officer. Even if the investigating officer is examined, the petitioners, the claimants will stick to their stand, and in support, the investigating officer would depose before the court in accordance with the charge sheet, which is stayed by the High Court. In these circumstances, the court has rightly dismissed the application, and no useful purpose would be served in that view of the matter. This court do not find any reasons to interfere. Accordingly dismissed. Yes, next.
Please. Number 35. Sangram S. Kulkarni, Shuraj S. Baldwin. Please.
My lord, this is a defendant's writ petition. My lord, they have filed an application for filing return statement, which has been rejected. 120 days.
Notice. Yes, 36.
My lord,
You are already appearing.
Please, madam.
Yes, this is matter after 2 weeks.
My lord,
Yes,
interim
36.
order may kind, because now it is.
The only granted is
My lord,
No, for the
one
first time.
submission. After the Karnataka amendment, my lord.
It has to go. I've dismissed several writ petitions
My lord.
because nothing is conferred with the court.
My lord, now
There is no discretion to the court.
but as far as the Karnataka amendment, this is an old suit, my lord, not a new suit.
Suit is of which year?
2021.
That's what is the submission you made when the interim order is granted.
No, not yet. It has come for the first time.
Oh, coming up for the
First
first
time.
time. Because when is the suit?
2021, my lord. During COVID,
2021 suit, you have not filed the return statement.
return
in
statement,
2025.
certain applications were filed, they were heard, they were recently rejected. Thereafter, this application came to be filed seeking per.
Return statement you have to file irrespective of the application.
My lord, as far as the other defendant is concerned, my lord, it is a collusive suit.
What do you say, whether that amendment is prospective or retrospective, or it has to be, will it apply to a suit which is filed much prior to it? Let us see that amendment.
Please.
CPC amendment.
That application is filed after the amendment.
Let us
my
see
lord.
what exactly it says. Where the defendant's fails to pay the return statement within the period of 30 days. So when it says, it means after that amendment date, any return statement to be filed, it has to be within so and so time.
No, my lord, as far as the amendment is concerned, if it is against the interest of the income tax, if it is against the interest of the SSC, then it in the case of Vatika developers case which is disposed of by the apex court, it has been held that a person who acts will act as per the law that is prevailing as on the day when the suit is filed, and he cannot presume that such a act may come in future and he is required to act accordingly. So the benefit benefit.
I will record like this.
No.
A suit of 2021, a person
No,
who has not filed
it is a mercy plea. It is a mercy plea, my lord, because it is a suit for partition. Without there being a written statement, no suit can be decided on merits.
Then the court will be waiting for you to file the written statement forever.
No, as far as
There should be
because
some
now,
valid reason Why you are not filing a
Evidence
written
has
statement?
not yet begun, my lord.
Huh?
Evidence has not yet begun. It is now posted for evidence for the first time. If we had crossed all the stage and at the time of argument,
Please substantiate your argument that this amendment doesn't apply to you.
yes, my lord. For that,
To argue.
tomorrow, my lord, I will make research and I will make submissions, my lord.
This is matter in the first week of March, interim order, earlier granted. is
No,
extended.
now
Interim
interim
order
order
has-
may kindly be granted. This is for the first time, my lord.
No, my lord, already, my lord has already dismissed such suit
Yes,
petitions, my lord.
This is matter day after tomorrow.
Yeah.
Please.
Yes, next.
Bill number 36. SP Patil.
Petitioner, my lord. The petitioner is a registered cooperative society, my lord. And initially, the petitioner had filed suit for declaration and consequential relief of possession, my lord. With respect to the property within ward number 4, VPC.
What is the IA?
The petitioner, therein plaintiff, had filed IA number 1, restraining the defendant to from demolishing the room within the suit property, my lord. And wherein the respondent, the defendant had filed IA number 3, of restraining the plaintiffs from disturbing and obstructing defendant from peaceful possession of the suit property, my lord. So
Notice the respondent. Yes, next.
my lord, there is another matter pending on same.
I'll post along with so and so.
Kindly be connected.
Yes, next 37.
Bill number 37. See Chaklab.
Please. The petitioner is a KSRTC employee, my lord. My lord,
What is the order of the ID?
my lord, transfer order, my lord. My lord, what happened, my lord? The petitioner has been reinstated on the basis of the court order, my lord.
Who is the respondent?
My lord, KSRTC.
Who takes notice?
I'll take one more.
So and so is likely to take notice.
My lord, connected matter has been stayed, my lord. Connected matter has been stayed, my lord.
Same order?
Same order, my lord. Same notification, same is. My lord.
Let him have the benefit of looking at it tomorrow. Yes, sir, 38.
Number 38. Hirema.
Plaintiff's petition. Plaintiff had filed a suit for specific performance against his brother, Sangaya. He died during the pendency of the suit. And since he is the elder brother and he had executed the agreement of sale, that is retained by the defendant. The plaintiff filed application order 11 rule 16 for directing him to produce that document. That has been rejected by this court, by the trial court.
Notice the respondent.
And my lord, trial court is insisting for me to lead evidence. For that reason,
This is matter on 9th of March. By the time the petitioner shall serve the notice, shall serve the hand summons on the counsel appearing for the respondent. We
Till
shall
then-
file a memo to that. We'll see on that. Yes, 39.
till then trial court may not. Or
Let it. Yes, next.
39. Satyanarayana Babaji.
Yes.
39.
From seal number 39 to 45, my lords, all these matters, my lords have heard the matter. This is again with regards to payment of interest on gratuity.
Yes.
My lord, I'm furnishing a list of cases, my lords.
Yes.
39 to 45, my lords.
40.
45, please. My
Same
lord,
order.
please.
Yes.
Grateful.
That amount will change.
My lords, I have given the table, the amount.
Table, according
Please.
to that. Yes, next.
Please. Grateful.
Order copy. Seal number 46. PV Gunja.
Yes.
The petitioners herein are lecturers in chemistry, my lord. Lecturers in chemistry. They had authored a manual.
Please come to your prayer.
Yes, my lord.
Prayer
Prayer is to
quash the proceedings on item number 12 at the meeting of respondent
inquiry has
number
been
one.
held against
Date held on
against the
14th
petitioners.
Who is respondent number 1?
Respondent is the university, my lord. The allegation is of plagiarism. There is a procedure guidelines issued by the university as to how
the allegation has to be met with. However, in this case, without the participation of the petitioners, without even calling them for an inquiry, an
Who
inquiry
appeals
is
for the Karnataka University?
Mr. Mali or Mr. Angdi, RH Angdi or
So
Mr.
and so is directed to take notice on behalf of the first respondent university. Does this matter in the first week of March?
Lord, because there is apprehension that they may be
Day after
suspended because
tomorrow?
not only has the inquiry been held behind the back of the petitioners, they have violated the procedure by placing the inquiry report before
Let him get
the
instructions tomorrow or day after tomorrow?
day after tomorrow.
Day after tomorrow. Yes, next.
Obliged.
Still number 47. Or Kupeluru.
No representation after 2 weeks. Yes, 48.
Still number 48. Kiran Kumar Patel.
12% FDT has been imposed. 12% FDT has been imposed by the
Oh, yes, same
respondent.
that. Similar order. Yes, 49.
I take notice for R1 to R.
Yes, 49.
Expect to appear for the petitioner. The petitioner is a cooperative society registered under the provisions of Karnataka Society Registration Act. Society sanctioned a loan to the respondent number 6, who is a member of the society.
Come to the prayer.
Please, ma'am. Prayer, not seeking, not crossing up annexure H and J.
Imprisoned order dated past with who is second respondent?
The second respondent is special officer, wherein he addressed letter to the third respondent to delete the name of the owner, sixth respondent, and enter the name of the second respondent in the property records. And based on the said letter, annexure J, the third respondent passed an order, deleted the name of the sixth respondent and entered the name of the second respondent. Now, the second respondent initiated steps to auction the said property.
This matter is supposed to be pending before the special court.
No, here,
Special court, as per the order of
special court passed an order for in respect of not before that I'll make submission. The sixth respondent availed a loan from me for 40 lakhs. Now here,
Whatever it is, what you have to clarify to the court is it whatever you are referring to, is it a matter pertaining to the special court?
Special court.
Once any matter pertaining to the.
So special court is decided. Now my charge is created. Section 32 of the Cooperative Societies Act, before passing this order, charge has been created by registered mortgage deed. Now my charge is there. Section 32 of the Cooperative Societies Act, first charge is cooperative society. Now let the second respondent sell the property, but first charge is in respect of the petitioner society. Therefore, whatever the
Even the Honorable Apex Court, in case of surface proceedings and this what is this? KPID Act, there is which is parametria with these provisions, has decided there are certain judgments on that.
No, I am not questioning the act of the special court or the special officer. Whatever they earn.
Yes, for the special court, that the council is there, no?
No, section 32 for a moment, Karnataka Cooperative Society.
We'll hear him. So second respondent, what is the advocate name? He's appearing from Bangalore. The other day also he appeared.
Please, Your Lordship. Yeah. Viresh Budihar, Your Lordship. I think Viresh Budihar.
Yes,
I will
so-
verify, Your Lordship. I will verify and
So I
make a
say,
submission.
to print his name, you find out.
Please.
So and so is directed to take notice on behalf of so and so. Does this matter day after tomorrow?
I'll take
No,
notice for
respond number 1 to 4, government.
134, Your
Will
Lordship.
also issue notice note.
3-4.
1, 3, 4,
Four.
notice so and so. SCGP takes notice.
Not 4 and 6, emergency, will also issue emergent notice.
Emergent notice.
5 and 6,
5 and 6.
Yes.
Yes. You want day after tomorrow or first week of March?
First week of March.
First week of March. Yes.
But
next.
only my anxiety is not to disperse that amount. This is only what I require.
If you want that, I have to hear it. If you want it, that order, I will post it on Wednesday.
First week of please.
April. Yes, next.
Not apart from the council for respond number 2, I will take emergent
Along
notice
with
also.
that, apart from the notice to so and so, petition is permitted to take out,
Emergent notice.
issue emergent notice,
Please,
to second respondent also.
Still number 50, Anandar Puri. For the petition.
Need a representations to consider the representations, my lords.
I made an application, my lords, to consider the representation
To whom?
to my lords, to the respondent number 1, 2 and 3 authority.
Who will consider it? There should be one officer who is competent
no,
to consider.
Competent, my lords, respondent number 1 and 2, my lords.
There will be only one officer to be considered.
Representation is of two in nature, my lords.
Hmm.
One is in respect of, my lords, allotting the site to open the school, primary school, that is concerned to the respondent number 1. Insofar as permission to the school is concerned to the respondent number 2.
How can there be those kind of, unless and until this is granted, you can't get a permission. So like one bird, two, in one thing you want to go, you want to have two. First of
Authorities
all,
are different.
You should pass through step 1.
Yes.
Once step 1 is passed through,
yeah,
then
only for
so we
respondent
will
number.
grant only one. What is
One.
that one respondent? Number 2.
Yes, only one, my lords.
Yes, that
Yes.
is one.
Yes.
Deputy Commissioner.
Yes.
Representation dated?
Representation dated, my lords, 3
to 26.
3 to 26, my lords.
What is this representation of?
Representation, my lords, I am, since there is a vacant land available at the certain places, my lords, that land has been allotted, my lords, to the present petitioner society is concerned to open the primary school is concerned, my lords. Since there is a rehabilitation center, entire village has been shifted. Since, my lords, in the rehabilitation center, my lords, there are no schools as such. So, my lords, the vacant land, the endorsement has been given by the respondent number 4 authority. Since this is a vacant land to the extent of 11 guntas, my lords, on the basis of that, my lords, I made a representation. This land is vacated to the open the.
Which provision there is an obligation to go grant that land for you?
Well, section 94, my lords, the discretionary power is given to the deputy commissioner, my lords, to allot the land to any of the society, my lords, or to the member who has been willing to.
The presented petition is filed. Seeing the following prayer. It is a case of the petitioner that they were given a representation to respondent number 1 to allot the land for establishment of a school on
3 to 2026.
on 3 to 2026, and the same is pending consideration. Hence, there may be a mandamus to the respondent to consider the same in accordance with law. Let it HCJP, who takes notice on behalf of
My lords,
all the respondents.
1 to 4 submits that they'll consider the same in accordance with law, considering the submission of the learned HCGP, and after hearing the learned counsel of the petition, this court is passing the following order. So the first respondent is directed to consider the representation dated 3 to 2026 in accordance with law within a period of 4 weeks.
Published.
Yes, next.
4. Number 51.
Please, my lord, the petitioners are questioning the scheme of management to the work institution, my lord. My lord, in violation of Rule 54 of the Work Rules 2017. Please, my lord, Annexure A is the order, my lord, approving the scheme of management, my lord. My lord, the earlier committee term is end, my lord. Afterwards, the earlier committee has passed a resolution. Based on that resolution, my lord, district officer has sent a proposal.
Come to that 6/12/2025 order.
Please, my lord.
Where is the 6/12/2025 order?
My lord, page number 18, my lord. Page number 18, my lord.
Read the order.
Bottom, my lord, order numbers. In exercise of the powers conferred under section 32(2)(b) of the Umeed Act 1995.
This was done on which date?
My lord, 6/12/2025, my lord, after passing of 3 years, my lord. My lord, my submission is this.
This is 2 months ago, this order is passed, more than 2 months.
Yes, yes. For that reason, I am submitting, my lord. My lord, the
Let them get
annexure H,
Let them get instructions, we will see.
please.
So and so. First respondent,
Arona.
you take, the AGA take notice, you take notice for
R4 and R5.
Huh?
Excuse me.
private respondents.
Yes.
R4 and R5, madam.
Juma Masjid,
Juma Masjid and Ali Sab, Ghosh Sab.
only 2.
Yes.
So and so takes notice for 4 and 5. State Waqf Board, who appears?
My lord, Muhammad Ali.
Muhammad Ali.
B. Muhammad Ali.
Is directed to Even the district of also he appears.
Yes, yes.
2, 3, so and so is directed to take notice. Issue emergent notice to 6, 6 to 15. This is matter in the first week. Yes, next.
Please.
Yes,
Number
52.
Lakshman Timatagan.
But this is a super partition separate portion. Here, my lord, there was a earlier partition was there. The defendants were not cooperative to effect the partition. Therefore, my lord, this partition suit can be filed. Here, my lord, after filing up the suit, the defendants have filed an application for amendment of the plain, amendment of the some inserting some branches of the brother of the father of the petitioner. Therefore, my lord, there are 4 to 49 persons have been added. Based on the, my lord, some of the properties which have been variation, the share of the properties variation. Therefore, they are necessary parties. The court below allowed the application for amendment. On that amendment, my lord, I made an application by seeking amendment of, my lord, some inserting some persons are not having any right over the property. Therefore, there may be deleted. And some of the properties which are fallen to the share of the brother of the father of the petitioner, they are also to be impleaded. Now the IA came to me rejected.
Where is order? Where is order?
Yes, your lordship kindly take page number 70, my lord, that relevant rejection. Page number 70, my lord, third sentence, my lord, hence in the from hence. Hence, at this stage, this court cannot decide whether the defendant number 4 to 40.
The year 2015.
Yes.
When was this inclusion of other properties was done?
But it was done in the INM 13, that is 2022.
What are you doing from 22 to 25?
But here, what happened after collecting the materials, they have made an application. Some of the properties.
How can it be? After 3 years, you keep quiet and now you say, well, you want to amend. Notice to the respondent.
Notice. Bill number 53.
May I please your ladyship?
Yes.
Rajesh.
Matter lies in an extremely narrow compass. I make a.
First, I would like to see the prayer.
Yes. Kindly have page 52. (51) and 52.
Who is respondent number 1?
Yes, Bemzil is respondent number 1, your ladyship. Belgaum Manufacturers Cooperative Industrial Estate Limited. They themselves say at page 58, please seek guidance from the court. Can I just take 1 second to put it in context?
Yes.
I make an application to them pointing out there's a business transfer agreement and I need their prior permission to transfer the shares and the asset. Very clear, it's under the bylaws and the lease, I'll show it. They say, listen, please go and get directions from the court or a clarification because between the private parties, some dispute is pending. That dispute has nothing to do with their statutory power by which they have to consider on merits. And consistently courts have said, you cannot abdicate your jurisdiction and your authority. So all that I'm saying as your ladyship directed in the previous matter, that they will decide this application.
Let's see where is this order you're seeking to quash.
Yes, page 56 at 58.
See?
56 at 58. That's annexed A. If you'll kindly have page 58, and with your permission, I'll just show the appropriate line.
Let's read this 57 and 58.
Yes. The Belgaum so-and-so has received a letter from us, the petitioner, as mentioned.
So who is the original allottee?
It's us. We have a lease.
So you want to transfer it to?
Yes, we have a business transfer.
To some other person.
Yes, to some other person.
Let's read.
Yes, just your ladyship may just have para 2. We have received legal notice and letters from partners of Standard Engineering and shareholders of Ashoka narrating many litigations and judgment have been.
Your company's name?
My company's name is twofold, Standard Engineering and Ashoka Iron Works Limited, P1 and P2. Can I just, before I place it, just give you 2 minutes perspective? So I have a lease and we have shares. The bylaws require me to seek their prior approval. Lease also says the same thing. I'll show the bylaw and the lease. So I have to knock on his door. I knocked on his door at page 126. That's the context. Now, between the private parties, there are some disputes which are pending, some in a company appeal, some in a suit. Both pertain to some monetary claim. So assuming the company courts decides, it will say that you have to sell your shares at so and so price. So it's a monetary claim. None of them can impinge on the jurisdiction and authority of the respondent corporation because they themselves by their bylaw and lease stipulate that if you do any transfer, you need my prior approval. So I have to go to him. He says in this letter, because you have some private disputes which are pending. Now, fortunately for us, your ladyship, the private respondent made an application, IA number 2, in a pending matter asking to stop this. He doesn't get any order. No order is passed by any court interdicting any of this issue. So as you indicated in, I think, 2 items earlier, once there is a power with the authority, that power has to be exercised. It cannot be put in cold storage or suspended animation for a prolonged period of time. So as the court had directed in those direction to decide this on merit in accordance with law.
No, before that, you are not an individual, you are a company.
Correct.
Between now, who has to take a decision from the side of the company to transfer its leasehold rights in favor of
Yes,
somebody?
I'm very grateful. So there's a business transfer agreement we have and a resolution which has been passed, which is at page 407. Sorry, 401.
Is there any other volume?
Sorry? 401.
There is no 401 in this. It's only the last.
Annexure V, 291125.
401. Yes.
Your ladyship sees, this is 29112025. This is the extract of the EGM which was held, and kindly have the box. Just over the box, you'll see resolved that pursuant to section so and so, so and so, so and so, so and so, consent of the shareholders of the companies accorded to the company to enter into the following related party transaction. And in the box, you'll see the nature of the transaction. Company has entered into a business transfer agreement with Ashok Hambarwadi and Jayant Hambarwadi and FEEPL for the sale of its business to FEEPL. So this is the EGM by which the transfer has to happen. For this, the regulations require, kindly just have one page, page 74.
You're saying that this company itself is into liquidation.
No, not into liquidation. They are transferring their business.
In other commercial courts, what are the matters?
That is a company appeal, ladyship, which is pending before the High Court. That is on valuation of shares. So if whichever way the outcome goes, one or the other party, perhaps me, will have to pay the other side to buy out their shareholding at a price which the court will determine.
So according to you, there is a consensus between the members of between the directors with regard to transfer.
Yes, a resolution has been passed at the EGM, which is the statutory requirement in terms of section 188. That is complied with. 74 will make it very clear.
He has approached the respondent with regard to, not to transfer or anything from
Your
your
Lordship,
company?
The private respondents will point out that do not do this because of the pending disputes, which is what the impugned order says. But I am only pointing out, just have 74. It will make it.
Private respondents or who?
Private respondents are the fight between us and the private respondents for valuation of shares. That is to be decided.
But then in this, the private respondent must also be a party.
We made them a party.
No, not to the writ petition, to this 29/11/2025 resolution.
Your ladyship, yes, they were all present and the voting happens at the EGM. They were also present and voting happens, and in the terms of the vote of 89.38%, the resolution was carried. So resolution has happened. Now just have page 74, it will make it clear.
No, because you have made them a parties, we have to hear them now before passing an order.
No, your lordship, I have served them. I'll just explain some urgency. Just bear with me for a minute. It's only respondent which has to do it. And ironically for us, respondent 9 sits on the board of respondent 1. Complete conflict of interest because he will ensure that no decision is made. But just have 74, it makes the position clear. Page 74.
Yes.
Your Lordship may have 21, bylaw 21. This is why I have to go to them.
Yes.
Any share held by a member of the association may, subject to bylaws, be sold to any other member, provided no sale may take place without the previous sanction of the committee, who will have the full discretion in granting or withholding any such sanction. Transfer may be in the form set out in the bylaw or any other form. 21(2), until the transfer of a share is registered, no right shall be acquired. So pursuant to the resolution at page 126, I have made that application. He now has to decide it, because the regulation says I have to go to you.
It is like now whatever order that this court is going to pass,
Yes.
it will be a final order, isn't it?
Your Lordship, I'm only saying this, authority has to decide.
Thought there are, if it is only official respondents,
Yes.
we can tell them and we can dispose
Yes.
it off.
You-
But you made so many people, we can't pass an order.
I'm just bear with me for a minute. I have made parties because I want to come to the court with transparency, and I have served all of them. But the relief I'm seeking, with greatest of respect, as the court knows, is only to the formal first respondent to decide. Kindly have the prayer again, as your leadership had asked me. It's a decision to them to dispose of the application. Please have page 52, Roman 2.
So shall now the court will say that you hear all other respondents and pass orders.
No, I'm saying the relief is directed against respondent number 2.
I understood what is the relief and what is the context
Correct.
under which you have made all these people a parties.
Yes.
So if it is an interim order, we can pass. If I have to pass a final order without notice, what is the purpose of making them a parties without notice to
Yes,
them?
I'll explain. Take it the other way. Supposing I come to court without making them a party, either the court can say, listen, you're trying to take an order behind somebody's back, or somebody can intervene and say, I should have been heard. I have come with complete transparency to say there is a background of disputes between the parties. It has no bearing upon the relief I'm seeking. That's why you have a necessary party and a proper party. So I have come with full clean hands, with full disclosure. I'm appealing to the court's conscience with full responsibility as an officer of the court. Your ladyship can consider passing interim prayer 2 if you don't want to pass the final order, which is direct them to dispose of the application filed in accordance with law without prejudice to the rights of any parties. That will entirely clear the picture. Now we are in February, March is coming. The transaction has to be completed. There are investors who will be bringing money. All of that will get into limbo. So I'm saying without prejudice, this prayer can be given subject to the outcome of the writ petition.
That is exactly what you want as a final prayer also.
The courts can all,
It's wanting to allowing the petition.
your lordship, the court can always pass an interim order in aid. I'm asking for in aid of, with this caveat myself, I'm saying, without prejudice to the contentions of any parties and any pending matter. That is their statutory authority. They have said come to court. Please have page 58. He's saying, last para, therefore the parties are requested to get the appropriate court in this regard. So I'm coming because he says I'm in a predicament. I'm requesting the court with all humility, please put them out of the predicament with this caveat, without prejudice and subject to the outcome. So nobody is prejudiced. Now, keeping this application pending, the entire transaction has been put in abeyance and on hold. Investors who have to bring in money will go away. March is round the corner. So I'm only appealing that this is something which the courts can do, mold the relief in the circumstances of the court while protecting the interests of all parties. I'm not saying pass a final order, allow the writ, off I go. I'm subjecting myself to the subject to the outcome. That courts always do, that whatever relief you're giving is subject to the outcome of the writ petition.
This is respondents. This is the first week of March.
Your Lordship, this second prayer, at least let them not keep it pending. Can it be then 2nd or 3rd of March, your ladyship?
3rd of March.
So grateful. Can we also serve Dasti in addition?
Yes.
May I, again, just
Yes.
may I just try with all humility one last time. I'm saying in the meantime, a nudge from the court that pendency will not come in the way. At least, my lord, it will be time bound and your ladyship will decide on 3rd. Just a little nudge, your lord. They may only say subject to that. At least they can process the application. Otherwise, every day's delay is fatal. Subject to the outcome, your ladyship, kindly consider. But they themselves say, please go to the court. I'm not coming willfully and of my own volition. It is under compulsion. And I have served everybody as a matter of abundant precaution to save time. So I'm coming fully with transparency and serving all respondents and private. My submission may be recorded that this will not come in the way of their processing, and some observation will just help. It will save time. Eventually, your ladyship can pass a.
Once the parties are before this court, it doesn't take 1 minute to pass an order. Let it come on the 3rd of March.
Very good.
45.
Great.
Cell number 54, Rajesh.
My lord, petitioner by me, my lord.
Yes.
My lord, in this
Yes.
matter, we are challenging the order passed by the respondent number 1 and 2 on the petition application filed by the petitioner before the accused respondent number 2 under the provision of the Maintenance and Welfare of Parents and Senior Citizens Act 2007, my lord.
Responding to match, they recall the order.
Impugned
What is this
order.
recalling the order?
My lord,
What is this recalling the order?
recalling the order, my lord, the second respondent has not considered the
No, order
prior.
of the order passed by the first respondent, this court will recall.
Yes, my lord. That one also I have sought. Along with that, second respondents also I sought for, because we sought for
Where
the
is the
cancel.
order? Only in Kannada. This is matter in the first week of March. Oblige.
My lord, date may be fixed, my lord, because there is an urgency. Even though
List on
there is an
1
order by
minute.
the my lord,
List on 5th of March.
5th of March.
my lord, one submission, my lord, one submission, my lord. In this matter, my lord, the first respondent has directed the respondents 3 and 4 to pay the maintenance of rupees 20,000. Since from 2023, they are not paying that amount also, my lord.
It's hardly a week. It's hardly a week, you argue, because all those documents are in Kannada. Yes,
Yes, my lord.
next.
Yes, ma'am.
55.
Much better.
Number 55. Yes, Pichkatti.
TP matter, medical termination of pregnancy. As on the date of registering the FIR, the age of the victim is 16 years, 3 months. And the gestation age of the fetus is 27 weeks. 27 weeks, 3 days. And as of today, 26 days, 26 weeks, 3 days. And as on today, it's 27, 26, 7 weeks, 1 day.
On today, it is 27 weeks.
1 day. Kindly immediately refer to the medical board.
Yes, what is this?
Yes, ma'am. So the similar matter has been considered by this honorable court.
Take that order.
My lords, with the constitution of the medical board, if they opine that it is a fit case for my lords termination of the pregnancy, it can be done, my lords.
She's 16 years old.
Please, madam.
16 years old now.
16 years, 3 months, madam.
Huh?
16 years, 3 months, as on the date of registering in the FIR.
So we'll pass an interim order now
Please, madam.
to constitute, because we don't know whether it is at this stage, whether
Whether
it
she's
can be
fit or-
termination of the pregnancy is
Only to-
correct in the interest of the girl or not.
My lords, the final order may be passed, subject to my lords, the condition that
So then first they should evaluate, and if it is,
yes,
then
yes,
they can do it.
yes, my lords, the medical board has to be headed by the
The
DHO
present
of the
petition
concerned
is
district.
filed. Seeking the following prayer. The petitioner, a minor girl, represented by the father, who is aged 16 years, 3 months, represented by her mother.
Mother.
Mother. On 19 to 2026, she was examined at Belgavi Institute of Medical Sciences and found to be 26 weeks, 2 days pregnant as a result of sexual assault. On 18 to 2026, the mother of the petitioner lodged a complaint in the police station. The case was registered as crime number 0071 of 2026. On 19 to 2026, when the petitioner was taken for a medical checkup, the pregnancy has crossed 20 weeks. It is stated that the respondent number 2 is the leading hospital in Karnataka for women and children with the best available facilities for pregnant women. Ultimately, what is that is stated in the writ petition?
Please, ma'am.
What is stated in the writ petition? In your petition, please point out, wish to be recorded. What is stated in your petition? Please point out. You say you all state about what is the complaint and all. You don't say what has happened. What do you want?
Hello.
Where did you say?
Prayer, my lord.
It's not about prayer.
Please, Lord, even at the grounds, my lord, the petitioner being a minor of so and so, victim of a so and so, my lord, sexual assault.
You should say what you are supposed to say, that she is so and so months pregnant. That can't be termed unless and until there are any orders from the court. It can't be done. Nothing.
My lord,
It is stated that the petitioner is a girl of 16 years and she is not interested to carry this child. And she is not willing to bear the child. And so, hence there may be a direction to the to the respondents to admit the child, respondents 2 and 3, to admit the child and take necessary medical steps to terminate the pregnancy. Learned CJP takes AGA takes notice on behalf of respondent number
1 and 4, my lords.
1 to 4 or 1 and 4.
1 and 4.
Then who appears for 2 and 3?
My lords, in fact, it is a, my lords,
Which Rajput? Which Rajput?
my lords, in
Which
fact,
Rajput?
it is a, my lords, the autonomous body of the government.
So there must be some standing council, panel councils.
My lords,
Who appears?
one by name Rajput appears, my lords.
Call him. It is there should be a representation before disposing of the petition.
Copy has been served.
Inform him.
Copy has been served. Copy has been served.
Inform him.
Please,
If he is not in the court, ask him to appear online.
Please.
Awesome.
End of the list.
End of.
Yes, next.
Orders matter cell number 56.
I'll not take up any matter where there is no urgency. All these, see this extension of time. Give that. A memo is filed, a letter is addressed seeking extension of time for 6 more months from January 2025 to dispose of OS number 23 of 2021. Earlier MFA number 100734 of 2022 was disposed of on 23/9/2022 within a period of 6 months from the date of receipt of the certified copy of the order. Earlier, time was on several occasions, extension of time was sought. It is stated that the officer is having the itinerary sitting at Siruguppa and every Friday and Saturday, and JJB sitting second half of Thursday. The dates available for hearing in second additional senior civil judge, Ballari, are only from Monday to first half of Thursday. In spite of the said efforts, the matter could not be disposed of. When the court has passed an order giving a direction to dispose of the matter within 6 months, unfortunately in this case, several times the matter's extension is sought. Again, now another 6 months time is sought. And finally, this court is granting 6 months time, and the learned judge shall make all efforts to complete this matter, and no further adjournment will be granted. Further time will be granted. Yes, 57.
57. Rajas Loli.
We are withdrawing the petition.
Take that. A memo is filed seeking to withdraw the petition. Dismissed as withdrawn. 58.
Dismiss as still number 58.
Look at it.
Reverend C. Patil.
The petition, Your Lordship.
You have an interim order in this?
Please, Your Lordship.
Interim order earlier granted is extended to the next.
Date
week
may
of
be
hearing.
fixed, Your Lordship.
Huh?
Date may be fixed, my Lords.
List, we can't give the dates. You can move the court in the month of March. Is 59?
59.
Memo for withdrawal. Give that memo. Memo is filed seeking to withdraw the petition. The memo is filed seeking to withdraw the petition. It is stated that writ petition is filed questioning the interim order in AP number 38 of 2022, and the said arbitration petition itself came to be disposed of on 23/2025. Hence, the petitioner wants to withdraw the petition. Accordingly, dismissed as withdrawn. 60.
Still number 60.
Next week.
Archana Magdu.
60 ballots.
For disposal.
There was an urgency on my, I've sought for vacation of the interim order.
You can do it.
Also
after
filed a
the-
memo that ballots will not claim equity ballots in the event the plaintiff succeeds in the suit. There's an order. Trial court and first appellate court have ballots dismissed the application for injunction. This honorable court was pleased to ballots direct an status quo order. So I filed a memo with the affidavit ballots of the defendant that ballots in the event, if the interim order is vacated today and ballots I'm permitted to construct, it's a temple. Tomorrow, if the plaintiff succeeds, I'll not claim any equity is what my.
Temple, where is this?
We are,
That means now the temple will be removed.
no, it's the construction is not of the temple.
You can't give permission of that nature. Yes.
May I request for,
The month of March. Interim order earlier granted is extended. Next.
if I may request for a date, ballots in detail.
No date I'll give because we can't fix the roster of the next bench.
Please.
Yes, 62.
One urgent still number 62. Deepak Magnur. Mahantesh Remat.
I filed a memo, my lord, for having served a copy on the trial court counsel.
Interim order is there?
No, my lord.
Yes, list this matter in the first week of March.
Please.
Yes, 63.
Please, my lord.
Still number 63. A.R. Patil. Al Bhatkurki.
This in the third week of March. Look at it in every case, wherever interim order is there, please make sure that is extended. 64.
64.
Memo for withdrawal.
Yes.
Respondent.
64.
Who appears?
Still number 64.
What is this with?
Baswan Gowda T.
List this
Petition
matter.
Harvey.
List this matter tomorrow. What is this liberty? Yes, next. 65.
65, my lords, I represent the respondent. Matter
Interim
stands
order, my
covered.
lords, is granted.
Lords, one
This is a-
submission, my lords. The respondent herein, my lords, is a cancer patient and she is awaiting her money for the treatment, my lords. It stands covered by the judgments of apex court, my lords. For a moment, my lords. Order, my lords.
These are the
passed by
matters which your ladyship ballots heard,
Please, my
I mean,
lords.
were pleased to hear
Relating
for
to
some
order
time.
passed by the-
Where ballots, the petitioners are ballots, the directors of ballots society and the district consumer forum.
Font I will hear and allow the writ petition.
A date may kindly be fixed, my lords. My lords, one judgment of the apex court, my lords, which
I
says.
understand. But the thing is, how can there be, there is an authority who will represent the society.
Please, my lords, even he is made as a party, my lords. He was
How can there be an order against directors? You can execute it against, you're not personally against the director.
But all these contentions, my lords, please, my lords, date may kindly.
This is matter in the first week of March.
My lords, third or fourth March, my lords. Third or fourth March, my lords. Third or fourth March, my lords, date.
First week of March, the respondents of the interim order earlier granted is extended. Yes, next.
Obliged.
66.
Is 66?
66.
Memo for
Hiremat,
withdrawal.
M. Hiremat.
Memo is filed for withdrawal.
Yes. Hiremat.
The petition is filed. The memo is filed seeking to withdraw the petition with a liberty to urge the right before the competent authority. Accordingly, the petition is dismissed as withdrawn with the liberty. Yes, 67.
67 minutes, it's a tender matter. Senior counsel is engaged.
67?
Taken at 2:30 minutes. He is engaged. Lords,
Let it
No, no,
go
my
after,
lords, my lords.
after in the month of March.
My lords, my lords, today they are opening the tenders, my lords. Yesterday also it was listed.
No, it is
before the
extended,
other
my
court.
lord. The time is extended till 7th March, my lord.
7th March.
Time is
Can,
extended
my lords,
till
can I
7th
have a
March.
date?
Yes.
This matters on 5th of March.
5th March.
Lords, can I request for my lords, 4th?
March.
Yes.
Yes,
Yes,
next.
ma'am.
Yes,
Plaintiff's appeal. That's IPA for response. Plaintiff's appeal, injunction application was filed in respect of portion of the Schedule A property, 8 property.
We'll list in the month of March.
Please.
Look at it.
First-
Interim order is there?
First time it,
Yes, March. Yes.
March first week.
So number 69. Girish Adhoc.
For the petitioner. This matter also, my lord, senior is appearing, my lord, so
But
he is
this
online.
matter was heard by my lord with respect to that cooperative society, my lord, section 70 and 71(3). I'm ready with the matter, my lord. I'll not take more than
Court
50.
is not ready. This is the month of March. Yes,
My lords, may I request, my lord, kindly, my lord, at 2:30 if it may be taken, or at least, my lord, tomorrow.
Number 70.
Lord, I may permit it to, my lord, otherwise make a submission. My lords were pleased to hear this matter on multiple occasions, my lord.
It will come in the month of March. Yes, next.
70. Vinayak Hegde. Girish Sulmani.
Yes, chapter service of notice. Look at it. Interim order is there. Extended 71.
Number 71.
My lords, I'm requesting 69, my lord, senior is online, my lords. Just for 2 minutes, my lord, it was listed on multiple occasions, my lord.
71.
Lord, there is by operation of law, administrator has to come into, Lord, has to take the charge. Lord, the elections are, Lord, yet to be declared. Lord, may kindly see, Lord, 2012, 2020, the earlier election, Lord, was scheduled, it was declared. And thereafter, Lord, 9/12/2025, the board gets vacated. In spite of today, there being a direction, Lord, now, by virtue of Annexure L, Lord, the elections are not being, Lord, conducted. Let there be, Lord, interim direction, Lord, to conduct the elections, Lord. It is their own order, Lord, which says that immediately, Lord, the elections are to be
As
required to be.
their prayer, Your Lordship, sought for amendment of bylaws, as I have submitted earlier, Your Lordship, notices were issued. And notice respond number 2.
Unless and until that is questioned, now will there be an interim order?
Please, Your Lordship.
Because annexure, by virtue of Annexure L,
Yes, 72.
any specific date, Lord, your Lordship,
Just on 9th of March. 72.
any earlier date?
Number 72.
Yes.
My lords, matter has been settled, my lords, in serial number 72. Joint memo has been filed. Last occasion, this court has directed me to produce the orders passed on the joint memo, my lords. I have produced the joint memo, my lords. Orders passed on the joint memo, my lords.
Where is that?
My lords, it is at page number 8. It is joint memo, orders passed on the joint memo is at page number 8, my lords.
Page number?
8 of the memo, my lords. Yesterday I have filed the memo.
In that, to direct the
Type.
Yes, this also in the month of March. Yes, next. Yes, 73.
If the due or not before 30, undertake to file affidavit, undertaking affidavit regarding deposit of the due, my lord.
Have you seen that?
I've seen that, ma'am.
Last
Anyway,
occasion-
substantial amount not paid, my lord, the short time up
Take
to
that.
30th of August.
Same date, my lord, I have mentioned, and they said 2 crore 42 lakhs.
See, let us see what is.
Yes, my lord.
the sought for 3 or 4 installments.
Amount of rupees 50 lakhs on 24/3, 50 lakhs on 24/5, 50 lakhs on 24/6, remaining 91 lakhs on or before 30/8/2026. That is how many times? Six months she is seeking.
Yes, ma'am. At least some time frame can be reduced, ma'am, because to 6 months is too long a time. Already we have initiated the
My lord,
proceedings
fire in
and
the factory, my lord, I am in the loss. I have to.
No, you have no argument.
Please, my lord, I agree for that. Even earlier,
Yours is a leg appeal, so you cannot say. that
earlier
it is-
occasion, only the reason is, my lord, I said 2 crore 21 lakh, they said 2 crore 42 lakhs, my lord. For that reason only it is urgent. Now we are ready to pay the 2 crore 42 lakhs, my lord, under the same
amount,
date.
even if you start the proceedings also, you can't recover it.
with single default clause. If any one payment is
One payment is not made, you are at liberty. You can continue the proceedings from there.
from
That
yes,
I will
yes,
observe.
yes.
Give the file. The present writ petition is filed, seeing the following prayer. When this matter came up on the last occasion and counsel to the petitioner submits that, in fact, if a reasonable time is granted, the petitioner is ready to pay the entire amount. Then this court has directed the petitioner to file an undertaking affidavit. Now, when affidavit is filed, as per the affidavit, it is stated that the outstanding loan, the outstanding amount of rupees 50 lakhs will be paid on 24/3/2026, 50 lakhs on 24/5/2026, 50 lakhs on 24/6/2026, and remaining rupees 91 lakh 44,141 on or before 30/8/2026. When counsel appearing for the respondent bank submits that the petitioner now sought for about 7 months to pay the entire amount, and this court may direct let them pay the entire arrears within a period of 3 months, considering the fact that the outstanding amount is more than
2 lakh 21,000 as per the notice. Now they said 2 lakh 42.
2 crores.
2 crores, sorry. 2 crore 42 lakhs, we are ready to
2
pay.
lakhs, and they filed an undertaking before this court, balancing the interest of the bank as well as the petitioner. This court is passing the following order. The petitioner shall deposit the outstanding loan amount of rupees 50 lakhs on 24/3, 50 lakhs, same as it is what I said. So and so. Next, number 2, if the petitioner fails to pay even one installment as undertaken before the court, the respondents are at liberty to initiate the proceedings as it stands today.
Yes, ma'am.
And as the petitioner is seeking amount till 6 months, whatever the incidental or other interest amounts as that accrues on the last installment, before the last installment, the same shall be informed to the petitioner, and the petitioner shall pay the same.
Already they have calculated till the end of March.
Whatever it
my
is,
lord.
my lord.
Yes, my
Let them
lord.
clear
Already
it.
they have
Let
calculated.
them clear it.
Yes, disposed of.
Great.
Next.
Dispose.
Next.
Still number 74. Gaurishantara Schmott.
In this filing, writ of mandamus directing, we have filed a compromise petition.
What are the matters pending located? Which year is your writ petition? Your source?
Compromise petition 15/4/2024.
For the order. What is the order passed? It is a grievance of the petitioner that he had filed a compromise petition on 15/4/2024. Until today, the trial court has not considered the same. You appear before the court and seek time, come to the court and ask for mandamus.
No, my lord, sir. Kindly produce the page number 21, my lord.
On 23/6/2025, 10/7/2025, 19/8/2025, 15/10/2025, 18/10/2012/2025.
My lord, sir.
Both parties and councils have not appeared in this case.
No, my lord, sir. Orally, we are objected, my lord, to pass the order. Orally, we have made submission before the court also.
If you have made
Subsequent-
oral submission, court will record that you are absent.
No, my lord, sir. They are not recording also, madam. Or
It
submission.
is unfair. The present,
Direction may be given, my lord, to
the
dispose of
present
the.
petition is filed in the following prayer. It is submitted that a compromise petition that's filed in the year 2024 is not considered till now. This court has called for a report from the concern. It is stated that due to various reasons, the same could not be considered. In fact, on the last couple of occasions, the respondent has sought for, the parties have sought for time. However, considering the fact that's an AP of 2024, the same shall be disposed of within a period of 3 months from the date of receipt of the copy of the order. Yes, next.
Please.
Yes, next.
Petition, my lord. I am challenging the annexure A appointing the ad hoc committee during the subsistence of order of status quo granted by this court. Your lordships may kindly see page 78. Till consideration of the approval of my committee, my lord.
What is this office objections?
Office objection is I have impleaded the president who represents the entire ad hoc committee. The office has directed me to implead all the members. It is not necessary since it is headed by the president.
What are your instructions, 75?
Please, Lord, the board has already resolved to constitute a committee for the purpose of holding elections to the very institution. And the ad hoc committee has been constituted for conducting of the elections.
Lord,
The ad
there is
hoc
a-
committee
there
will
is a
not
specific-
carry
there is a
any.
This is the third round of literally 3 administrators were appointed. All 3 office members were quashed and appointment of administrator was withheld by this honorable court, holding that until consideration of my approval for the formation of committee, the status quo has been maintained. And again, another writ petition is filed. And in that writ petition also, there is an observation that until consideration of my approval of the committee, they shall not form, the status quo shall be maintained. During subsistence of the same, again, ad hoc committee is appointed.
What is your remedy? Again, you will file another petition. Again, we will say another status
if-
quo.
if
that status quo is violated, then you question it.
Earlier writ petition, I have questioned in the contempt proceedings. During the pendency of that contempt proceedings, my lord, again, this order is passed. I have already initiated contempt proceedings against the second writ petition. And the third writ petition, there was a direction to again consider my approval and till consideration, they shall maintain status quo. Again, this ad hoc committee is not appointed.
No, ad hoc committee is appointed after the expiry of the period of the committee.
What does status quo means?
Till the consideration of the application, they shall be maintained the status quo.
Let us see that. Where is that order? Where is that order?
Let's
Section
kindly
A,
see.
page 28, my lord.
Page?
Page 28.
Yes.
May I read, my lord?
No.
Please.
Where is the order which you're relying?
Uh,
Saying that contrary to the orders, this
Yes,
is
my lord.
done.
Order is at annexure H, page, operative portion, page 78.
Light of the petition deserves to succeed. Issued by the first respondent, the matter is remanded back to the hands of the first respondent. The first respondent to redo the exercise bearing in mind the observations. The first respondent shall, while reconsidering, also consider the proposal. Where do you get that?
Lord, page 99, para 3. The coordinate bench of this court direct the first respondent to take appropriate decision within an outer limit of 4 weeks until the status quo was said to be prevailed. Notwithstanding the status quo, the impugned action of.
Observation, that is an observation.
Yes.
In this order, where is an order of status quo?
Lord, the order of status quo is in the writ petition, page 78, my lord.
That we will know. That's why I asked which order you are asking
78,
for.
page 5.
After that, this writ petition is filed.
Please.
Now you have to look at this writ petition, we will not look at the earlier order.
Sir, for a while, my lord, page 78 may kindly see, paragraph 5. Lord, in view of the above submission, since the period of appointment of an administrator has expired, writ petition insofar as challenge to order of appointment is.
This is a difficulty. Now, which writ petition you are questioning, which order you want, we don't know.
No,
After this order, what has happened? You tell the court.
After this order, this appointment, an impugned order is passed, my lord, appointing ad hoc committee without consideration of my proposal for the formation of new committee. Let them show by the impugned order, they have considered my application, I have no case.
The order which is been appointing ad hoc committee is only for the management of the institution. Neither the petitioner who is before this court as on this day.
Are you managing the affairs of the
Yes, my lord.
committee?
Till today I am managing the appeal.
His
Lord,
term is concluded
literally,
long
until
back.
consideration of my proposal, status quo
What is
shall
the
prevail.
difficulty in
My submission, my
what is
lord.
the difficulty in considering his case?
No, my lord, my submission is that his period has concluded long back. 2022 only, he is no more office in charge.
Lord-
He himself has produced a document to show
What
that
is the tenure of your office?
2022 concluded.
He is confusing. My committee ends on 12/6/2023. I have given a proposal on 12/6/2022 itself, as per Rule 54 of the Work
What
Rules.
is the proposal?
Proposal, we have formed the new committee, my lord, by calling the election and in the presence of district work officer, there was election and we have been appointed as president and the committee members. That proposal is pending consideration. That's why this honorable court twice directed their proposal shall be considered. Until then, status quo shall prevail. So they have to consider my proposal, my lord.
What is the term of office?
3 years, my lord.
When that will expire?
12/6/2023.
Already
So
over.
from that day till now.
Till now,
there
I
should
am
be
managing.
status quo.
He's
Yes,
enjoying
till
the-
now, there is a status quo, my lord. Please,
Why status quo?
status quo because I have been continued, my lord,
Should you be continued after your term?
Allah, I have given the proposal, my lord, Rule
What is
54,
what is the proposal?
proposal annexure F, my lord. Rule 54 may kindly be seen.
Read it.
The board shall appoint mutawalis or constitute managing committees under clause G.
Section?
Rule 54, my lord. Rule 54 of Rules 2017.
Correct. Fifty-four.
Yes.
Hmm.
The board shall appoint mutawalis or constitute managing committees under clause G of subsection 2 of section 32 on receipt of proposal forwarded in accordance with the respective scheme of management. Such committees shall initiate process of constitution of succeeding committee as per the approved scheme of management 3 months prior to the expiry of term of committee and shall complete the entire process of constitution of succeeding committee within 2 months prior to expiry of the term of the committee. The district officer of the respective district shall supervise the process of appointment, constitution of succeeding committee. If in the event of existing committee fails to initiate and complete the process for constitution of succeeding committee within the time prescribed under sub rule 2 of Rule 52 of district work officer shall initiate such process within 2 months prior to the expiry of the term of the existing committee and complete the process prior to expiry of terms of the existing committee. So I have given in the presence of district work officer, a committee is constituted prior to 3 months of my completion of term, and that has been submitted.
What is the limited role and limited work you will do now?
Please, Milo.
What will you do after that?
After
For the new committee, whatever this process has to go on, that you have to.
Yes, Milo.
That's only that's a
Oh,
limited
yes,
thing.
Yes, Milo.
So why are you fighting for this?
Allah, I have formed the committee, my lord, in the presence of district work officer. A proposal has been sent. So until consideration of proposal, there is a status quo order. So they have violated thrice, my lord, the order of this honorable court. Earlier, another writ petition was filed.
Not necessary,
Please.
not necessary to look into that. Yes.
My lord, this process of 54/4 is required to be done by the district work officer, not by the petitioner. He has not produced any record to show before the court that this has been done. And the proposal which has been
Respondent
sent.
shall come up with the objections.
Please, Lord, till consideration, my lord.
Yes.
Please. Lord, at least yesterday they have undertaken before this honorable court.
I will not. Yes.
No,
please.
notice, how can you submit?
The petition shall file that the respondent shall come up with their objections.
Please.
Yes.
Hearing on IS, number 76. Sri Shenlo. Prashant S. Kardevar.
Interim order earlier granted is extended till then.
There is an absolute interim order. There is already an absolute interim order. Please.
If interim order is there, then it is extended till the executive hearing.
Still number 77.
List in the month of
AP,
March.
Agade?
Yes, 77.
Mark. 77. Agade?
Last date, government director take
Interim
instruction.
order is there in this.
No.
List in the month of first week of March. Yes, 78.
Still number 78.
Last occasion, my
Yes,
lords, Lordship
also.
have asked in order, my lords,
Required
directing them to
instructions.
file objections. It's the last chance given, my lords, where constitutional validity of section 7 is, my lords.
Same, this also second week of March.
March.
80.
Still number 80.
There was only one submission regarding 79. But it appears it was mentioned in the morning, but I was informed later.
Oh.
There is an application for vacating stay. If only a date could be fixed, Malad, in the first week, Malad.
How the
I
other
can
court
understand,
will
Manoj,
hear
but,
this matter on 11th of March.
Please, please.
79, 11th of March.
Yes.
Yes, 80.
I appear for the petitioner, my lords, in serial number 80, my lords. It requires consideration, my lords, because it's a unilateral cancellation of the tender awarded to me without there being any notice.
Yes, this is matter after vacation. Yes, 81, after, in the month of
Interim
March.
order may kindly be extended, my lords, in serial number 80.
81.
81.
81 also. 81 also, second week of March.
81 present, your lords.
Huh?
81 in 81, my lord, the matter is heard in length. That both the parties directed to be present here. My lord, my party is not my party is not present because her daughter has been admitted in the hospital. She is suffering from the opposition fan disorder, means she cannot control his anger and emotional. So she is under treatment now, and our proposal put the proposal to her. Right now, she is dissented from their proposal now.
This is matter in the second week of March. Yes, next 82.
Stay, my lord, continue.
Earlier order is there.
There.
Interim order is extended till then 82.
Still number 82. Jagdish Patil.
Respond number 1 and 2.
Patil.
Yes.
Same order.
First week of Interim March. order is there, your lords.
Interim
First week.
orders. Not first week, second week.
Please.
83.
Still number 83. Rajshekhar Bihali.
I am for appellant, my lord. Senior counsel is not keeping well. Kindly next week, my lord.
Today I have filed, my lordship. Objection to delay condemnation application I have filed.
The third week of March.
Please,
Yes, 84.
please.
84. Come on, continue.
Insurance company अपनी liability. No, there is no permit. The award
It is after amendment or before amendment? Accident.
after amendment.
It is submitted that the accident has taken place after the amendment and there is no permit. Insurance company is not liable. Same 50%, 4 weeks. 85.
85. Pajabati.
No deal after amendment.
Yes, no, this is driving no driving license after amendment.
Please.
50%. In these two cases, no permission to withdraw.
Please.
Yes, 86.
No permission.
It's also same.
Still
No
number
DL
86.
after amendment. Payment
Yes,
recovery order has
same,
challenged.
same order.
Payment recovery order has.
Yes, notice to respondents. Yes,
Then
87.
B group matter still number 87. J. Shetty.
Requesting for next week. Next week, my lord.
no, next
Documents
week.
are in Kannada language, my lord.
This is matter in the month of April. Yes, 88.
April.
Please.
88. Jia Gachirmat. 88.
This also in the month of April. Look at it if interim order is there extra. Yes, next. Yes, 90.
90.
Please, my lord, appearing for petitioner, my lord. My lord's wife petition for announcement of interim order.
Yes, this is matter in the fourth week of March.
Fourth week.
Yes, 92.
My lord, there is no interim order. Short date make request for short.
Fourth week of March is short date. Yes, next, 92.
Number 80. Please, sir. 92. Rajshekhar Gunjal. Chetan Munawali.
Yes,
Appear for
list in the-
respondent.
list in the month of April. Look at it, interim order is there extend. 93.
No interim.
Remote action. Still number 90.
No interim order.
Yes, yes, 93.
No interim. 93.
This also in the month of April. Yes, 95.
95.
94 interim order may extend.
In all the matters, wherever interim order is there, it will be extended. 95.
95. Chetan Munawali. K. Manil Kumar.
Look at it, if interim order is there, extend in the month of April. 96.
My lords, may I seek in the month of March, my lords?
96.
Yes.
96.
96.
96.
This also in the month of April. Look at it, if it is in interim order is there, extend. Yes.
Passover matters. 100.
Lord,
For
90
dismissal,
99.
100. For dismissal, 100. Sunil S. Desai.
Please, my lords. My lords, in the connected matter, my lords, 100.3, my lords. I need to take steps, my lords.
Then why were you not present when the matter is called?
My lords, we were present, my lords. Last occasion, we were present, my lords.
Just continued in the dismissal caption, delete from the caption for dismissal.
Please,
Yes.
Lord, there are submissions in serial number 99. I had a benefit of interim order in all the matters.
Orders will be granted,
In all
extended.
the matters.
In all the matters, it will be extended.
Please. Great.
Yes. Where is the Passover matter?
Passover matters. Passover matters.
You appear.
No, Lordship. Serial number 94.
94.
97, sorry, 97.
Hmm.
It was settled actually as per my client's instruction.
But my party says, my lord, she has not signed on the memo.
Delete from Parker. Yes, next. Passover matters.
Passover matters, serial number 20. This is Jnana Swami.
Yes.
Jnana Swami.
What is that? 20? Where is he? Business matter tomorrow. Yes, next.
26. Serial number 28.
Please, my lord, in this case, they are proceeded on the ground that there is a stay of section 25 before Honorable Supreme Court. My lord. There is no stay of section 25 before Honorable Supreme Court. In the other case, I made a compilation. So there is still today, my lord, section 25 is operating.
He is operating on other provision. No, 25 later it is. That's what you
Please,
said.
only one compilation, sir. Only 2 minutes, I will take. Because this is regularly this issue is coming before this Honorable Court. My lord, initially, my lord, the act has been struck down, my lord. The entire act has been struck down, my lord. Subsequently, my lord, at page 29.
No, initially entire act has been struck
Struck
down.
down.
You appealed against it.
Appeal, my lord. Only one minute.
All provisions are stayed initially.
Please. Section page 29, my lord. The entire order has been stayed, my lord. First order. Subsequently, my lord, in respect of page 30, the only in respect of age relaxation of the Archakas has been vacated. Stay has been vacated. Page 30. 32, my lord, page 32, state filed an, page 33, stay in respect of 25 as initially is granted. In respect, section 25 has been stayed. Stay in respect of section 25 as a vacated. It means that there is operation of section 25. Stay is operating against section 25. No. Initially, my lord, act.
No, let us understand
Please.
this. Entire act is struck down by this.
Please.
So that order first is in entirety it is stayed.
Please.
That is entire provisions are operating.
Please.
Then in respect of 25, that stay is vacated.
It is not operating.
Vacated means
It is not operating.
it's not operating.
It means stay. Yes, ma'am. It means the section 20, it is not there.
There in the eye of law,
Please,
there is no
please.
act of, there
Please.
is no provision like 25.
Please. Subsequently, my lord, state filed an application for modification to implement these provisions of section 25. Page 35, my lord. Page 35. The application is filed. What Supreme Court said is, since there is amendment to the act, you go before the High Court. Section 25 entire structure has been changed. So the Honorable Supreme Court said, you go before the High Court, challenge the validity of the act itself.
What happened?
Subsequently, my lord, again, the Amendment Act has been struck down by this Honorable Court. Entire Amendment Act been struck down. That is at page 36. Judgment start with page 36. That page 88 is the relevant portion. Page 88, paragraph 100. The entire act was been, the Amendment Act was been struck down.
Then what happened?
So subsequently, the entire Amendment Act judgment of this Honorable Court has been entirely stayed by this Honorable Supreme Court at page 89. The relevant page is page 90. Page 90, my lord, there is absolute stay for the judgment passed by this Honorable Court. It means after amendment, section 25 is operating. My lord. That was clarified by the another coordinate bench, my lord, in this case, page 91. So this court said, see, since there is the entire act, the entire judgment is been stayed by this Honorable Court, passed by this Honorable Court, stayed by Supreme Court.
No,
Section
it is prior to amendment one time it is struck down, after amendment second time.
Both,
second
my lord. Prior to amendment also, my lord, it was struck down, and later, my lord, 2 times, my lord, they amended.
By this court.
Yes.
This court, please, now there is the absolute stay for the amended act also. See, the judgment passed by this Honorable Court,
Provisions are in operation according to you.
please, my lord, except in respect of age relaxation, which is granted by this under the old act. Old act age, under the old act, age relaxation, there is no stay order. So the subsequent amendment is only in respect of, majorly in respect of section 25, amended act. So amended act has been, see, we moved an application, please.
Now, my lord, thereafter, a notification came to be, my lord, issued by
When section 25 is in operation, when it is a notified institution, the government has got all the authority and power to.
to constitute, my lord, the management body.
Yes.
Now that, my lord, notification came to be again challenged, my lord, before this honorable court, which again there is a interim order granted by this honorable court, annexure D.
With all these says, how the management of a temple will go on?
ಅದೇ ಆಗ್ತಾ ಇಲ್ಲ. So that's why, my lord, in the interest of the temple,
Page number. There
page
is no
number.
interest now. Page number?
Yes, my lord. 138. Same petitioner. In respect of this petitioner, my lord, that notification is stayed.
My lord, we are not assisted this court, my lord.
We can't follow this.
Detail, my lord, I shall place. I shall place entire detail. I'll place, my lord, entire detail of the previous petition.
No, petition is there.
Same petitioner.
Seeing an interim order which doesn't contain any reasons. First of all, an interim order is not binding on the other court. And the second is an interim order which doesn't even contain reasons. Why should we consider? Now, if you argue on the merits, I'm not concerned with that order. If you say on what ground, on what reasons this notification issued by them is bad, then only we can consider.
No, now I'm not seeking, challenging any notification issued, because the notification issued.
What are you questioning before?
That's what I'm submitting, my lord. Now notification was issued, my lord, on the basis of, my lord, stay granted by the Honorable Apex Court in the appeals preferred by the state. For constitution of, my lord, management committees, my lord, to the several temples. Again, my lord, several temples, my lord, approached this honorable court, my lord, wherein petitioner number 1 had also approached this honorable court seeking stay of the notification for constitution of management committee, my lord, by the government operating the provisions of section 25. Now, while that is, my lord, is stayed, and the, my lord, the validity of the section 25 and the entire act, my lord, when is pending before the honorable Apex Court, this, my lord, is a trust which is registered as back as 1966.
Oh, subject, you're pausing there. Your submission is not correct. Where did the Supreme Court has stayed these provisions? That order of the High Court is stayed by virtue of the stay granted. All the provisions are existing in the statute book. They have every right to do it.
Yes, my lord. But now what has happened is, operating, my lord, the provisions of section 25 notification was issued. That and the constitution of management committee, my lord, by the government in respect of this petitioner trust is stayed. My prayer may kindly be seen, my lord. What I'm seeking is only this much. Issue a writ of mandamus or any other writ in the like nature directing the respondents herein to allow the petitioners to function and administer the first petitioner temple trust as per the rules.
The relief you sought itself cannot be granted with the High Court.
One second.
Why should the High Court declare you as a so-and-so? If you want any declaration, go to the tribunal.
1 second.
We don't have a tribunal here, endowment.
One second, my lord, I'm submitting. At least
there is Raja Dharmika Parshat, my lord. It is empowered to decide under section 28.
What I'm submitting is this. My lord, even the petition filed, my lord, before the district court, my lord, under the provisions of 1920 Act, my lord, there is a objection raised regarding maintainability, my lord. What I'm seeking is, till the constitution of the committee of management as per section 25 of the Karnataka Hindu Religious and Charitable Endowments Act 1997 upon the final outcome of the decision of Honorable Apex Court.
That's not for this court.
I'll place, my lord, entire records, my lord, of the previous petition also.
Notice to the respondent. So and so, you take notice.
Let them take a notice, my lord, and make submission. 1, 2, 3.
For the respondents.
1, 2, 3, my lord.
All
They are government, my lord.
AGA is directed to take notice on behalf of the respondents. They shall file their objections, list in the month of April. Yes, next.
My lord, since there is an urgent, let it come, my lord, in the next month. I'll take it chance, my lord, in the next month, my lord, because this is the famous and
list in the 4th week of March.
Every day, my lord, the function is.
No. This is not the way. Like, how will, I'm not able to understand how the temples will function. One order, other order stayed, every order is stayed. And there should be some scheme in place. Committee, duration of the committee, 5 years. After that, something else will come. Whoever is there managing, they will manage it for decades together. Yes, next.
This is a very big temple, my lord, famous in South, my lord, North Karnataka, Andhra, and Maharashtra and Goa. Devotees follow, my lord, in lakhs together. They also.
In Andhra and Telangana, we do not see this kind of litigation there, because there is everything. Now, what litigation we see? A trustee is appointed. If he is having some criminal cases or contrary to the provisions of the Act, he is appointed, they'll come to the court. Otherwise, no appointment of a trustee will be stayed. And every whatever 5 years or 3, whatever is the duration, accordingly it will happen. A temple like TTD, which is the largest and the biggest temple in terms of revenue, that was never stayed. If it keeps on the High Court interfering with this, the affairs, how will the system run?
Since, my lord, everything was smoothly going on till, my lord, this repeal.
Everybody, no, one has to accept the change.
That is there, my lord.
Yeah, and
Since,
once it is a notified temple, you cannot say, being a trustee erstwhile, I am running it smoothly. You don't know how smooth they are going to run it. So we have to give a chance.
now there is nobody at the helm. Whole difficulty, my lord.
Yeah, any signature?
55, yes. 55, serial number Passover matter.
Who appears in your matter?
Lord, I communicated the counsel for the respondent number 2 and 3, that is the hospital, my lord. He
Then I'll
appears-
record that in spite of his
Please,
service of
please.
notice.
Please,
So
please.
and so, the
Grateful.
present petition, who has taken this order, half of it? Ishwant has taken, no, from there. It is submitted that there may be a direction to the respondents. And the respondents, Learned AGA had brought to the notice of this court an order passed under petition number 110142 of 2025, dated 30th December 2025. Extract the order, paragraph number 6 and 7.
That's
The-
other one condition may be imposed. If the fetus is available,
Huh?
if the fetus of a baby is available, it has to be preserved and sent for FSL to the jurisdictional police.
Where is that direction?
It is not there in the, but in some other
That is
cases.
to
it
be
is
added,
there.
madam.
So that to determine. it-
Criminal case.
Determine the
paternity-
For the criminal case.
For DNA test.
The, in the light of the, this court has heard the arguments of the counsel appearing for the respondent number
2 and 3 for the
2
hospital.
and 3. The counsel appearing for the respondent 2 and 3, the petitioner has already served, and this court has passed over the matter to inform the counsel. But in spite of the same, there is no representation on behalf of the counsel. Having heard the counsel for the petitioner and the counsel for the Learned AGA, considering the fact that the girl is a victim of a sexual offense and who is aged about 16 months and odd. And
16
considering the.
16 years.
16 years, 3 months.
16
madam.
years, 16 years.
3 months.
Considering the dignity of the girl, this court deems it appropriate to pass the following order. Respondent number 2 and 3 are directed to constitute a committee and to constitute a multidisciplinary panel of doctors, and they shall give they shall examine the girl and opine whether she is fit and able to undergo termination of the pregnancy within a period of 3 days. 3 days is fine?
3 days.
my lord.
Huh?
3 days is sufficient.
Within a period of 3 days from the day. Today itself you will get the order.
Please,
Within a
operator,
period of
please.
3 days from the date of receipt of the copy of the order. Thereafter, if, as per the report, if the pregnancy can be terminated, the respondent shall take immediate steps for the termination of the pregnancy. Number 3, after the termination of the pregnancy, in case of not after, in case of termination of pregnancy, the fetus shall be preserved
Preserved.
by the
By the author.
respondents number 2 and
2 and 3.
accordingly disposed of.
My lord, 3.
2 and 3.
One submission.
When?
2 and 3, 2 and 3.
2 and 3.
Please.
2 and 3.
2
2 and 3. Respondent number 2 and 3.
and 3.
Yes.
No, one submission, my lord. Not 3 days, my lord. Tomorrow, my lord. Report can be made by tomorrow itself.
What is that?
Report, medical examination can be done tomorrow itself, my lord.
Medical examination.
By tomorrow,
Within.
within a day,
Within
ma'am.
1 day.
Please,
From the date of receipt of the copy of the.
Grateful. Grateful. Much obliged.
Done? Signature.
जल्दी उतर ला रही मैडम जल्दी उतर ला रही
Thank you, sir.
लास्ट टाइम